the attendant, it shall be heard.
Welcome. We have about 7 hours of argument time requested, so only ask for the time that you need, not the time that you wish. We are familiar with the briefs and the records, and if we have further questions, we will definitely keep asking them. People versus Rivera is submitted. Feliciano versus Caban. Okay, you're going to have 3 minutes. Kay Anthony, appellant. Respondent? I'm sorry, what? You didn't have a cross appeal, did you? No, you don't, it doesn't work that way. You just get your time. 4, 2, 5, and 4. Arias versus City of New York, appellant. That is submitted. Michael Bust versus Consolidated Edison, appellant. Respondent? 5, 1, and 5. People versus Santiago, appellant. Respondent? 6, 1, and 6. Westside Marquis versus Maldonado, appellant. Respondent? 5, 1, and 6. Corbex Inc. versus New York City School Construction, appellant. Respondent? 6, 1, and 6. Mather versus HFZ Kick 30th Street, appellant.
Appellant defendants, 5 and 1.
Okay, so there's only 2 of the 3 appellants are here. Is there anyone else here?
No, we have everybody.
Was there a third appellant?
There isn't. No, there's 2 appellants.
Oh, I got 3 briefs. Okay. 5, 1, 5, 1, and 5. People versus Dobson, appellant.
Good afternoon, Your Honor. John Boyd, request 5 and 2.
Respondent? 5, 2, and 5. DeFrancesco versus McEnroy, appellant.
Your Honor, appellant request 7 and 2.
Respondent? 6, 1, and 6. Abramov versus 230 Paz, appellant. Respondent? Respondent? I'm sorry, what? 2? 4, 2, 4, and 2. Ramirez versus Texera Bakery, appellant.
Good afternoon. Request 5 and 1, Your Honor.
Respondent? Do you have a, oh, you do have a cross appeal. 5 and 1 and 5 and 1. People versus Moore, appellant. Respondent? I'll give you 7, 1, and 7, and if we have more questions, we'll keep asking them. DeWinter versus Equinox Greenwich Avenue, appellant.
Good afternoon. Appellant request 5 and 1, Your Honor.
Respondent?
4, Your Honor.
5, 1, and 4. People versus McTaggart, appellant. That case is submitted. Ataj Real Estate versus Stern. There are 2 cases on the calendar that we heard together. Appellant.
Good afternoon, Your Honor. Appellant request 7 and 2.
Respondent. 6, 1, and 6. JC and Infant versus 2078 Arthur is submitted. So the first case on for argument today is Feliciano versus Caban.
Good afternoon, Your Honors. May it please the Court, John Chepwong on behalf of the respondents. Just very briefly, I wanted to address a couple of points from this case. First, the standard of review. The enhanced benefits here were denied by a tie vote, meaning that the petitioner must establish causation and an accident as a matter of law, yet she relied entirely on speculation that was not binding on the Board of Trustees. I know Your Honors are familiar with the record here, but just wanted to make that point, both in terms of whether she contracted COVID-19 at work, as well as whether catching a well-known respiratory disease while performing undisputedly ordinary police work was a qualifying accident. And I think it's telling in this case that she pivots to the board's decisions in other cases that don't apply here. But what's relevant is what happened in her case, what evidence she presented, especially because there was a tie vote here and there was actually no factual determination made by the board in this case. So what matters under the law is what the record shows as a matter of law for ADR. And I would just note that the presumption that she's seeking is something that was never formally adopted by the board in any instance. The legislature declined to adopt, to change anything about ADR as it applied to COVID-19, despite having done so in many other circumstances. And I'd also add that the board members explained exactly what was different about this case versus the cases in which ADR benefits had been granted. So for the same reasons, discovery into those other cases would not have made a difference in this case, Your Honors. Seeing unless there's any other questions, we would rest on our brief for the remainder of our arguments.
Thank you very much.
Thank you, Your Honors.
Hey, Anthony?
Greetings, Justices, and may it please the Court. I'm Michael Weinstein on behalf of the appellant. There is one standard in predispositioned hearings for the return of a child, and that standard is imminent risk.
Before we get into the
Yes,
merits,
Justice.
there's a big issue lurking that I would like you to address initially, which is the mootness doctrine, and particularly in the context of the recent Court of Appeals decision in matter of Joshua, which specifically addresses when it's appropriate to apply the mootness doctrine in the context of permanency hearings. Why doesn't that case, why isn't it dispositive in terms of us finding that the issue is moot?
So, Justice, Joshua J. is distinguishable for a variety of reasons. The first, there really is one holding from Joshua J., which is that there will not be a blanket exception for mootness, and that this court and all courts in this...
That was only one of the two holdings.
Of course, I promise I'll get to the
The
other
other one is the one that pertains to us.
Yes. In terms of the other holding, the question was very different. Here, it's a matter of what standard and what was occurring. If you look at what occurred in Joshua J., who the hearing was before, it was before a referee. And so I don't have the benefit of having been there at the trial level for Joshua J. or have access to the transcripts. But just from statutorily, where a referee hears a hearing in family court, that referee can't enter an order. And the quote in Joshua J. was the referee saying, I can't do this.
Right, but it seems to be a very broad holding in terms of how a court applies the issue of the mootness doctrine in permanency hearings. And in fact, the child was returned shortly after that determination, so it didn't evade reviews. The child got returned very quickly. And there are a lot of determinations in these type of proceedings, which makes it unlikely that it will evade review. So what's your response to that?
So when we look at precisely what the issue is here in terms of judicial economy, in terms of the standard being applied, those were issues not discussed by the Court of Appeals in Joshua J. This hearing was on for a permanency hearing, and yes, of course, just like in Joshua J. At that hearing, the appellant requested that her child be returned. There's been one standard since the beginning of the Family Court Act in 1963. That standard is imminent risk. This court has said last year in matter of Emmanuel C.F., talking about judicial efficiency, going through cases more quickly, this was a perfect opportunity for the family court to have actually applied that holding.
Let me ask you something. Even if we got to the merits, how do we deal with the Court of Appeals decision in Jamie, which seems to, on the merits, reject the argument that you're making here?
So in Jamie, well, There's a constitutional due process here at play that wasn't directly addressed by the Court of Appeals, in Jamie J.
But didn't they address this, basically the same exact issue and found that the imminent harm standard was not the one to be applied in these circumstances?
I was trying to pull up the quote from memory. I'm sorry. I was reading it last night. So in Jamie J specifically, at the point where they said that they were merely reading the statute, procedurally it was at a different point. Different things were happening. And so, sure, in a broad scope, certain events are very similar. But these cases are distinguishable on the fact pattern, which, because of how things are kept secret between the
You're saying none of these cases have any effect beyond the particular fact patterns of the issues decided in that particular case? So the Jamie decision has no effect beyond that particular decision? Usually the Court of Appeals takes cases because they think they'll have some broader impact.
To be precise, it's not that they don't have any impact. It's that they're limited in their scope and how it applies to this particular proceeding.
Okay.
Counsel, aren't we limited, I'm sorry.
I'm sorry, the time was up, but go ahead.
Counsel, aren't we limited by the few things that was submitted on the record here? How can we make a good, how can we review and come up with a good decision when the record is lacking?
So I don't know, well, imminent risk, and that being the standard, was brought up in the transcript. I'm sorry, that was brought up on February 11th at the permanency hearing, where both the attorney for the child and trial counsel for my client brought up that imminent risk was the standard.
I'm troubled by the little bit of record that is here. I wish there had been more record.
Thank you.
Good afternoon, Your Honors, and may it please the Court, Lauren O'Brien on behalf of ACS. Appellants are asking this court to make a broad pronouncement about the scope of the family court's authority under the relevant statutes. But as Your Honors note, this case is undeniably moot, and the family court made no broad ruling about its authority. In contrast,
What do you think matter of Joshua means, how it applies to this particular case?
I think that matter of Joshua is on all fours with this case. It considered a similar ruling in a similar permanency hearing, and it determined that the narrow exception to mootness does not apply in this specific context. But the one way in which I would contrast matter of Joshua J. is that in that case, we have a very explicit statement from the family court saying, I do not have authority to make that kind of ruling in this case, and no matter what I hear today, I am not going to order a return of the
If we
child.
accept that was not the case here, then it's an even stronger argument that
Exactly.
it's moot here, even more so than it would be.
Correct. I think that
matter of
that
Joshua.
contrast makes it clear that here what we have is a standard exercise of the family court's discretion to consider the information that was presented to it and determine whether it would be in the best interests of the child to return the child that day, or whether it should take the time to conduct a 1028 hearing.
So is that the standard that we're using, best interest, or is it imminent risk?
Imminent risk.
So if this court doesn't have to reach that question, of course, because of the threshold mootness issue, but if this court were to reach the merits, it's clearly laid out in the statute that the standard to be applied at a permanency hearing, regardless at what stage of the proceeding, is the best interest and safety of the child.
In fact, this court has said that numerous times, right?
Right.
As most recently as July of last year.
Right, and the Court of Appeals has also said it in matter of Joshua J. And so there really isn't any basis in the statutes to sort of import the standard applied during the separate.
Well, we don't know if there's an exception. We can't really review it because the record is lacking, correct?
So I think
On both sides.
if what you're referring to is sort of the mootness issue, because the case hadn't proceeded very far, this was sort of the first permanency hearing.
Counsel, I'm very familiar with family court. More of a record could have been submitted on this appeal,
So
correct?
So the court, what all the court had before it was really the permanency hearing report. And so, if this court were to reach the merits, I think it could say that based on what it was presented in the permanency hearing report, it was a proper exercise of the court's discretion to then want to have
We don't know, it's an
1028
incomplete record.
hearing.
so.
But again, this court there's no need for this court to reach those issues. This, as all parties agree, this appeal is moot, and there is no basis to apply the very, very narrow exception to the mootness doctrine as.
Thank you.
Thank you very much.
I'm sorry, did you have anything else you wanted to argue?
That was all. We would just like to ask this court to dismiss the appeal as moot.
Thank you very much.
Good afternoon, Lawyers for Children on behalf of the child, Anthony K. I just have a couple of thoughts on the mootness issue, one of which is, if you look at the language that Jamie J. had for us, I'm sorry, Joshua J., there's a lot of J's in this case. The court said, to the extent the mother contends that the referee erred by claiming to lack the power to return the child, the record before us does not demonstrate the issue is likely to recur. And that was the crux of why they did not find it to meet the mootness, the exception to the mootness doctrine. It wasn't likely to recur. They hadn't made their record. I would argue here we have made our record that it is likely to occur. And frankly, it happens very frequently in the family court, as is demonstrated by the fact that we have this appeal here, and we also had the appeal going up to Joshua J. The issue in Joshua J. was the record was too thin for the court to find it was an abuse of discretion not to find that there was an exception to
How
the
is
mootness.
this record different?
This record is different because we made the record that, first of all, we pointed to the Joshua J. case to say, hey, this does happen. It happens quite frequently. And we cited in our briefings to the fact that 32% of cases in the family court are predisposition having their permanency hearings. It really does, because of the backlog, happen all the time. So then we get to the threshold question. What does the state have to show if a parent demands return of a child in a permanency hearing? And what the city is saying is just best interest, because that's what 1089 says. And that's the statutory, that is the statutory provision that tells us what the standard is. And what I'd like to argue, and what I think actually Jamie J. tells us is, and the Supreme Court of the entire country has told us, is that parents and children have a constitutional right to family integrity. And that family integrity is so strong that the showing required in order to keep a family apart must be pre-fact finding. It must be imminent risk. And I'd like to read.
What case says that?
I'm going to
You're
read to you
asking us
Jamie
to make
J.
new law.
Yeah, I'm going to read. Jamie J. says this to us. It says, we have little doubt that the due process clause would be offended. Would be offended. We have little doubt it would be offended if a state were to attempt to force the breakup of a natural family over the objection of the parents and their children without some showing of unfitness, and for the sole reason that to do so was thought to be in the children's best interest. They are rejecting the notion that best interest prevails. The parent must be found unfit first. And I urge this court to look at matter of Elizabeth C., which really puts it nicely when it talks about it's the constitutionally protected liberty interest that provides us with the imminent risk standard. The imminent risk standard does not come from 1028. 1028 reflects back on the state what it is that must be shown in order to meet the constitutional requirement, not to separate a family unless there's been some showing that is greater than best interest. Otherwise, the state could always say, we think this parent could do better. But we know, Troxel tells us that. The Supreme Court has told us this for decades.
Counsel, we're missing multiple key documents in this record, such as the transcript of the Family Courts Act 1027 hearing held prior to the Family Court's September 16, 2024 order, granting ACS application for removal pending a final order of disposition, as well as the family court order that ACS cites in its brief. This record is slim.
So
You want us to do a holistic review? Submit your records.
I think what the question is right now, though, before you, that we're really seeking is guidance as to what to do when you have parents who, for no fault of their own, are stuck in a situation where...
Counsel, I'm sympathetic to you, but I want to just read to you the matter of Joshua. Generally, an appeal will be considered moot unless the rights of the party will be directly affected by the determination of the appeal and the interest of the party is an immediate consequence of the judgment. In the next adjournment, she got her son.
And our argument is other parents should not have to go through and wait 10 days, because one thing you hear a lot is, it was only 10 days, it was only 10 days. If you're 3 years old, you're ripped from your parents.
Counsel, I'm sympathetic with you. Augment the record.
Thank you. And I have no other points.
So just in terms of mootness again, there's actually a key quote within Joshua J. that distinguishes this case from it. Counsel were asked in Joshua J. to produce one example, just one example, that this issue had happened before. And I'm sorry, that was Jamie J. that it happened before. And now we have 2 cases where it's happened before. We have Joshua J. and we have our proceeding. This issue is recurring, and we're seeing it recur after examples previously could not be cited in those proceedings that the Court of Appeals didn't have the benefit of. In terms of the Joshua J. question that or the quote that you just read, Justice Rosado, the 32% that my colleague quoted comes actually from Judge Rivera's dissent in Joshua J. And as we're getting more and more cases, and as this court has seen and written about all these delays in family court, it is inevitable that more and more cases, just like the one on appeal here today, will confront this issue. This issue will evade review because, as we're aware, these permanency hearings are held every 6 months, and through no fault of the court or anyone really, cases have been delayed on appeal beyond those 6 months, and you're just going to get the problem again and again. Also, in terms of can the issue be resolved, in terms of if a relief is granted, what effect would that relief have? A parent can request their child's return multiple times. It's not just you get one hearing like in Florida, for example. I'm barred there, so I feel confident asserting that. In New York, you can have it for good cause shown at any time. And so you could have a circumstance where a parent is denied a 1028, but if this court were to grant relief here at a subsequent hearing where circumstances have changed, that parent gets the hearing again. And it could be at a permanency hearing to prevent delay of adjudication. And at that time, the court should apply the one standard that has always existed as a matter of due process to protect parents and children, which is imminent risk.
Thank you.
All right, thank you, Justices.
Michael Bus versus Consolidated Edison.
Good afternoon, Your Honors. The plain language of Section 65 of the New York Public Service Law makes clear that the fees Con Ed imposed in this case are prohibited. The trial court erred.
Can you lift the microphone up just a little bit, please?
Is this better?
A little bit better, thank you.
The trial court erred in deciding that it could not interpret the plain language of the statute. Con Ed does not contest that the language is plain and unambiguous, nor does it contest that there are no...
Counsel, do you want to address the primary issue, which is the doctrine of primary jurisdiction and how that should affect our determination in this case?
I'm happy to, Your Honor, yes. So primary jurisdiction does not apply to pure issues of law, such as the issues raised in this case, in issues statutory interpretation. This isn't a case where the PSC's special expertise is needed to resolve factual issues.
And how are you addressing the decision in Riverdale versus Brooklyn Union Gas, which seems to be pretty on point with this case? Why is that case distinguishable from this case?
So in that case, the challenge to the public service law, the plaintiffs argued that the fee was not just and reasonable under Section 65(6) of the Public Service Law. So what is just and reasonable is a determination that's delegated to the Public Service Commission. We're not arguing this isn't a just and reasonable fee. It's one that's prohibited by the statute. So that's the distinction between...
What happens if your position is not accepted at the PSC?
If our position is not accepted that the fee is prohibited by Section 65?
Right.
So respectfully, the PSC...
Where would that leave you?
Excuse me?
Where would that leave you?
So this issue hasn't been presented to the PSC, but respectfully, the PSC's opinion on the interpretation of the pure language of the statute isn't entitled to any deference, in this case by the court. It's an issue of pure law. So if the PSC did decide the other way, that wouldn't change the court's analysis, and this is what happened in Kowarski. The PSC had held.
You say the issue is not pending at the PSC?
Correct. So Con Ed does not dispute that the statute is plain and language is plain and unambiguous, nor does it dispute there are any factual issues that need to be resolved by the PSC, that there are no factual issues that need to be resolved by the PSC. Accordingly, it's a pure issue of law that can and should be resolved by the court. The court erred in not interpreting the statute and by delegating this decision to the PSC.
Thank you.
Good afternoon. May it please the court. Craig Bergman from Davis Polk and Wardwell for the respondent Con Edison. The claims in this action are that Con Edison has breached its tariffs and engaged in deceptive billing practices by charging no access fees that Mr. Mickelbust alleges are not authorized by the tariffs or the public service law. Now, in just the last 16 months, this court has held across 2 different cases that claims of tariff violation, claims of public service law violation, and claims of deceptive utility billing practices all may be referred to the Public Service Commission for first instance review pursuant to the primary jurisdiction doctrine. And the second department has separately held that claims that a utility was prohibited in particular from charging the very no access fees at issue in this case also may be referred to the PSC. We submit that against that backdrop, there is simply no basis to conclude that the motion court abused its discretion in dismissing this case without prejudice, purely to afford the commission an opportunity to weigh in before any further court proceedings. Unless there are any questions from the court, I'm happy to leave it there, Your Honors.
Thank you.
The decision that counsel referred to by the second department is Kaye, and in that case, the fee at issue was no access fee being charged for denying the utility access to inspect the equipment. That's not what was at issue here. Here, Con Ed's contractor was attempting to gain access for the purpose of installing a smart meter. Con Ed says that an installation of a smart meter necessarily involves inspection or examination, and there may be some incidental inspection or examination, but it seeks to install a smart meter regardless of whether the meter in place complies with PSC regulations. It could pass or fail an inspection, but the meter is going to be replaced. So the purpose was not to inspect or examine. The purpose of entry was to install a new meter. That's prohibited under Section 65. Thank you.
Thank you. People versus Santiago.
Thank you, Your Honor, and may it please the court. Coley Hungate appearing under the student practice order for Mr. Santiago. Your Honor, these are not excited utterances because the declarant evinced in a capacity for reflection. Within minutes of police arriving on scene, he's telling officers, hold on, I need to go take my belongings and close my locker because he's afraid of them being stolen. He was just outside before the incident happened, and he's telling police, I need to get my jacket because it's freezing cold outside. These are showing a capacity to reflect on what happened before and also what is going to happen in the future. He's telling police, I need to get my wallet and keys.
Assuming we agree with you, wouldn't it just be harmless error?
No, Your Honor.
Why not?
Because the evidence in this case was not overwhelming. The jury and the people both relied on these statements heavily at summation and at deliberation, which the Court of Appeals and the First Department have both found to be reversible by itself. And the jury acquitted on the top count in this case. Additionally, the testimony of the two security guards is just as consistent with Mr. Santiago's testimony at trial, and the people needed these statements to distinguish that testimony from Mr. Santiago's. The wound pattern that the declarant, Mr. Richardson, had was just as consistent, and in fact, exactly what we would expect.
Wasn't there testimony from the security guard that they witnessed this, the defendant on top of the other individual, and they witnessed the knife being handed over to a separate individual?
So yes, Your Honor, but what the two security guards also testified to, so in the trial transcript at page 143, security guard Torrey says, quote, "I didn't see no weapon," and security guard Sani says, "I couldn't be specific as to what happened with the knife." Neither of them actually saw the stabbing occur, and I'll mention that Mr. Sani also, in his testimony at trial, couldn't even identify the declarant in the courtroom. So the defendant in the courtroom. So it's not like you have Kojak up on the stand with irrefutable trial testimony. This is inconsistent, and it's simply not enough.
Counsel, didn't one of the security guards testify, like my colleague said, that the victim was chased, tackled, pinned on the floor, and then the defendant was over him, hitting him hard multiple times, even though they didn't see the knife? And then the defendant gets up and he's stabbed?
Well, it's true, Your Honor, that one of the security guards testified that he...
Couldn't the jury find that he did it based on just that testimony?
I don't think so, Your Honor, because if you look at all the other lack of evidence in this case, and I think the fact the jury acquitted on the top count shows that they didn't find that testimony particularly compelling. And additionally,
Isn't there also evidence that the defendant gives the knife to Cesario, and when the knife is taken from Cesario by the police, there's blood on it?
Yes, Your Honor, but again, I think that is just as consistent with Mr. Santiago's testimony, because he says he was afraid of the knife after the incident happened, and he wanted to give it to his friend in the shelter, Mr. Cesario. That by itself, without independent corroborating evidence, the fact of the matter is, and this is what the Court of Appeals...
So you're saying that the only way that this could be corroborated is somebody actually saw him stab the complainant. Other than that, doesn't matter. Even though we have all these other things that we've all just mentioned, doesn't matter unless the actual stabbing was seen?
Well, Your Honor, what the Court of Appeals in Edwards said is that when the only direct evidence of guilt, that is the only statement that can actually link the defendant to intent, is in the form of hearsay statements, we should be extremely hesitant about admitting them. And so here, this is the only direct evidence of that happening. And that's what the declarant statements are saying. When the police first arrive on scene, the declarant is saying, "He had a knife and he stabbed me." I mean, first of all, these aren't the kind of statements that you would expect of some kind of spontaneous declaration. It's not like, "Oh, he stabbed me in the side." He's saying, that guy had the knife and he came up and he stabbed me.
Is the defendant denying that he had the knife?
Yes, Your Honor. The defendant is, he's claiming that prior to the incident, he did not possess the weapon.
But at some point, he did come into possession of the knife, correct? Under his own testimony.
Correct, Your Honor.
What we have here, isn't it simply a credibility determination that was up to the jury?
No, Your Honor. This is a pure question of law, which this court is equally well determined to make. On the excited utterance point, it's a clear question of law, but on this factual determination, the standard, it goes back to harmless error, and that is a legal question. So if the evidence is not overwhelming, it's the obligation of this court to reverse. If I can turn briefly to the Sandoval point, perhaps in the minute time I have remaining, it's a unique posture here. And so what happens is that pre-trial, the people sought to elicit the name of this prior felony. And usually the trial court makes these, prevents that name from coming in as a defensive protective rule. But mid-trial, counsel revisited that claim after the court had already determined that it would be unduly prejudicial to let those facts in, makes this bizarre ruling, not allowing the jury to hear the probative prior felony, which was a crime of theft, which the defendant was basically offering to take a hit on credibility.
Well, the trade-off was, you're not going to mention that it's only grand larceny, and the people are not going to bring out what went on during that grand larceny, the stroller, the baby. So that was the trade-off, and then defense decided not to accept it, that they're going to elicit that it's grand larceny.
Well, Your Honor, the abuse of discretion here is that the trial court's ruling didn't comply with the purpose of Sandoval. It didn't give the jury any probative evidence of credibility, if I might answer your question briefly, and resulted on all this prejudice coming in. So the fact that the judge determined these facts were unduly prejudicial, and the defendant effectively offered to give up a bit of credibility hit to prevent these egregious facts, which the judge determined were egregious, from coming in, and that's abuse of discretion. Thank you, Your Honors.
May it please the court, Andrew Seawald for the people. Good afternoon, Your Honors.
So, counsel, if we find that there was no excited utterance, where does that leave us in terms of harmless error?
Could easily find harmless error. The excited utterance, let's just be clear about what the statement was. It was, he stabbed me, and I can't believe that guy had a knife here in the shelter. Or what's he doing with the knife in the shelter, something like that. That piece of evidence was really insignificant in comparison to the testimony from the 2 security guards, the surveillance footage that showed the defendant holding something that resembled the knife before he went out to that floor of the shelter, and the evidence that the defendant, or the testimony from the guards that the defendant was the aggressor, that he pursued the victim, that he tackled him, that he
Threw a metal garbage can at him?
threw a garbage can at him,
Chased him?
was punching at him, and then...
And the complainant wasn't bleeding before all of that, correct?
Correct.
When he says you're on the wrong floor, the complainant has no puncture wounds, he's not bleeding.
Correct. I mean, the obvious inference, even if it is a technically an inference, was that the defendant stabbed the victim.
Now,
yes.
I think one of the assertions was that they fell on the knife and he stabbed himself. Was the jury able to hear that and consider it?
Yes. So that was the defendant's story, and my adversary argues that the security guard's testimony was just as consistent with the defendant's testimony as it was with the conclusion that the defendant was guilty, with the jury's verdict. And that's just not the case at all, because the defendant had the victim as the aggressor, the victim as the one who threw the garbage pail, and the victim as the one who was the instigator here. So that was the opposite of what the security guards testified to. And the other key piece of evidence was that the defendant got rid of the knife afterwards by giving it to his friend Cesario, who then hid the knife inside of a box inside of his locker. So in that context, the excited utterance that he stabbed me and what's that guy doing with the knife here was really insignificant. That was not what the jury's verdict was hinging on in this particular case. And the evidence that the jury did rely on was overwhelming, I would submit to you. So the court could easily find harmless error. But I would also just say that on the merits of the excited utterance ruling itself, this was a statement that the victim made within 15 minutes of having been stabbed in the arm quite severely, so severely that his arm was still spurting blood when the police arrived, to the point that the first officer on the scene, immediately applied a tourniquet to him. I would also point out that the victim made this statement to the police, started saying he stabbed me as the police are approaching. This was not some formal interrogation that the police conducted of the victim, and so these circumstances, even if this victim in these circumstances was in the setting of a homeless shelter where all of his belongings were in his cubicle and he wanted to make sure that he had them when he went to the hospital, this was still, there was still plenty of evidence that this was an excited utterance. And I would also note that in the initial argument about the admissibility of this statement as an excited utterance, the defense didn't even contest that the admissibility of these particular statements. The defense only argued that the later statements after the victim was seated and then was in the ambulance shouldn't come in as excited utterances. Later on, the next day,
So moving on to the Sandoval.
Yes.
Was that ever by the court?
I would submit that that was not error by the court. Again, if it was harmless error. The difference.
I think all parties agreed on the notion that the underlying facts of that conviction were egregious.
Yes. Yes. I mean, I think that the comparison between the original ruling, which was the defendant had been convicted of 2 misdemeanors and 1 felony, from that to he was convicted of 2 misdemeanors and 1 felony, which was a grand larceny, and he used his baby in a stroller as a means of committing that grand larceny, was not such a wide gap that that would have been the reason why the jury would not have credited the defendant's testimony. And I would note that it was.
But defense counsel was not supposed to elicit the grand larceny, right?
Well, when defense counsel asked about whether he
that wasn't part
could
of
elicit it.
That was the Sandoval compromise, wasn't it?
The compromise was 2 misdemeanors and 1 felony.
Without specifying the felony.
Correct. And then defense counsel said, can I elicit the grand larceny, that it was a grand larceny, the felony? And the judge said, if you do, then the people will be able to elicit the underlying facts of that grand larceny. Defense counsel said, okay, I would concede that, but let me think about whether to do that. And then when the defendant testified, defense counsel did elicit that it was a grand larceny, and the people confirmed that that fact had opened the door to the people now being able to elicit the underlying facts. Judge said yes, and the people elicited it. So, thank you.
Thank you, Your Honors. On admission, the people point to nothing in the record to show the declarant was actually excited. The test here is not whether they were sick or in pain, it's whether were they startled by some kind of act to render incapable of reflecting, and that's not argued here. They rely purely on a frivolous preservation argument. In the record, it says, the counsel asked to, quote, curtail any of the body-worn camera that depicts the victim. You'll notice that's not in the opposing's brief because they ignore it. Preservation is not an issue here. On harm, the reason that the admission of these statements was harmful was because these are repeated declarations to investigating police officers, not EMS personnel, that the defendant had a knife and intentionally stabbed him. That destroys and completely contradicts defendant's testimony at trial. That contradiction is what makes it inherently harmful to our case because it prevents it's statements that were not cross-examined at trial and it's inconsistent with our trial testimony of the defendant and that leads to the harm in this case. We ask to reverse.
Thank you, and thank you very much for your service.
Thank you very much.
The next case is Westside Marquis versus Maldonado.
Good afternoon, Your Honors, and may it please the court. I'm Thomas Honan, and I'm with Manhattan Legal Services, and we represent the appellant. When the landlord delayed 16 months and ultimately offered the appellant a renewal lease on November 7th, 2019, and revoked the prior preferential rent in that renewal lease, it did so in violation of Rent Stabilization Law 26-511C14. That statute, as amended by the HSTPA.
How is the tenant in the premises? Is in the premises ultimately because there was an agreement many years before which settled some dispute as to how this building was coming out of Mitchell-Lama.
Yes, after the building,
So you can't make an agreement to get out of rent regulation. But does this situation fall within that typical situation of an agreement to get out of rent regulation? Because after all, here there's a proceeding going on, and it's settled with DHCR's agreement. Does that make this different?
no, and I'd point to Extel Belnord v. Upman, where there was an agreement between the parties. DHCR ordered that agreement effectively, and that agreement was also found to have violated the rent stabilization law.
Did it violate the rent regulation law when it was made?
That is a distinction. So this agreement we concede it did not violate the rent stabilization law when it was made. And the creation of the...
There's nothing nefarious about that agreement when it was made, right?
Correct. But if you apply that agreement to the renewal lease that was offered after the HSTPA, after the passage of the HSTPA, and you're applying rent stabilization law 26-511C14 as the law is stated, and applying that to the renewal lease that was offered, then the statute is clear that it's a limitation on what the landlord can
At least there's
charge.
a difference in terms of what the Housing Stability Act does when you're seeking to take advantage of a rent which really, or an agreement which really meant to undercut rent regulation, and an agreement such as this, which was perfectly consistent with the law at the time it was made, and DHCR gave it its imprimatur to it.
Well, when you're operating within a highly regulated field such as rent stabilization, the Court of Appeals in Metropolitan Regina has stated that you can't assume the rent laws to stay static.
Let me ask something more specific about that then, because HSTPA says the former rent controls unless it's otherwise authorized by law. Some of the courts have already held that this rent order by DHCR is increased otherwise authorized by law. What's your response to that?
Yeah, I have two responses to that. First, we would submit that a private agreement is not an authorization by law.
Why isn't this different than a private agreement? Because it was a dispute that the DHCR resolved, and that is the function of the DHCR. It basically operates on a parallel track with the courts to make rent orders all the time about rents and what is the correct rent, and issues enforceable orders, which are valid until and unless there's an Article 78 overturning them.
So DHCR, the order that DHCR issued was entirely based on the agreement. The order says based on the agreement between the parties. You cannot distinguish that order from the agreement. The only thing that creates this bifurcation of a legal regulated rent and a preferential rent.
The order from the agreement. I mean, it's like any dispute which you have in court, that the court either signs off on it or it doesn't.
Yeah, and this court has found that when a so ordered stipulation or when an agreement that can't be distinguished from an order violates the rent stabilization law, it cannot be enforced.
But it didn't violate the rent stabilization law when it was made.
That's correct, but it does violate the rent stabilization law in its applicability. And rent stabilization law 26-511C14 says upon renewal. When that renewal lease was offered, you have to apply that statute to the renewal lease. And the statute limits what the landlord can charge in that renewal lease and says you cannot revoke this preferential rent. So the only thing that the landlord can rely on to revoke that preferential rent is this agreement, this private agreement that cannot result in a circumvention of the rent stabilization law.
Thank you.
Thank you, Your Honors. May it please the court. My name is Ethan Cohen from Rosenberg and Estes, representing the respondent. Here,
So the Housing Stability Act would not permit you to do what's been done here under current law. How do you get out of those provisions?
respectfully, Your Honor, as counsel argued and as this court has held and Court of Appeals has held, the statute must be applied as written by its plain language. The plain language specifically says the prior rent may be adjusted by guidelines increases and any other increases authorized by law. Here, there's a 2006 DHR final order.
Counsel, why should the DHCR final order be treated as law? Normally, when that phraseology is used, increases authorized by law, it's referring to statutes, that there's some statute out there that allows for it. But this is simply, as already been indicated in the questioning, a settlement agreement which the DHCR so ordered. How does that turn it into a law?
Your Honor, this 2006 order was the result of a RSL 26513A proceeding that was mandated by the Court of Appeals and KLSM for the landlord to get rental increases to its legal regulated rent. That was litigated for 18 months before DHCR. DHCR then issued a final order saying that we're increasing the legal rent to $500 per room.
Wait a minute, but that wasn't that wasn't their determination, right? They just rubber stamped, for lack of a better word, the agreement between the parties. They didn't rule on their own that the legal regulated rent is $500 per room per year.
The landlord was seeking a much higher rent. The DHCR
Right, and then they settled it down, right?
the DHCR.
That $500 number, where did it come from? Did it come from DHCR or did it come from the negotiations from the parties?
My understanding, it was litigated with DHCR and the attorneys, and it was the equitable resolution to protect the current Mitchell-Lama tenants. And that was a final DHCR order.
What was DHCR's role in that proceeding?
They litigated and negotiated with the parties for 18 months, both with sophisticated counsel, to come to this resolution to protect the current Mitchell-Lama tenants. They then issued a final administrative order that the landlord has complied with for decades, that court has enforced for decades, as an order in several cases that says the collectability of the legal regulated rent is governed by the agreement which is incorporated into the order. That agreement protected only certain Mitchell-Lama tenants, the elderly former Mitchell-Lama tenants who had low income. Here, the result
So it didn't apply to all the tenants who were in the building at that time, only to certain
it
tenants.
applied to all the buildings in the tenant at that time, but now we're 2 decades later, and the
So it
tenant
applied to everybody in the building at the time.
yes, everyone who's a part of that proceeding. And the tenant here is seeking a windfall. The result here is not drastic. The landlord is seeking to collect the legal regulated rent for a rent stabilized apartment.
How do you grapple with HSTPA, which
I think
clearly
it's-
says
sorry.
whenever there's a preferential rent, that it has with a new, and this clearly is a preferential rent.
Your Honor, the plain language of the HSCPA does not say that. The legislature specifically used the broadest possible language to say guidelines increases and any other increases authorized by law. If they wanted to invalidate prior court orders or administrative orders, they could have easily said so.
If DHCR makes an order, is there anything which says that's not something which is authorized by law?
No, there's actually several cases cited in our brief, voluminous cases that say an administrative order has preclusive effect and is entitled to the force of law. It cannot be collaterally attacked. It is a lawful administrative order. It is a lawful
The order here
increase.
itself, didn't it say that it didn't have any precedential value and that it was based on the settlement agreement?
I'm sorry, Your Honor?
The order here itself by DHCR, didn't it say that it had no precedential value and that it was based on the settlement of the parties?
It says it set the legal regulated rent for the units and says that the collectability of the rent is governed by the agreement. I don't believe it said it had no precedential value.
My question about it not having precedential value.
I believe it does have precedential value. It was enforced by courts for decades.
The order didn't say itself that it did not have precedential value?
I do not believe it did. I can look at the language of the order, but
Whether it has precedential, it may not have precedential value in that its decision doesn't guide or determine another proceeding, but it doesn't mean that it doesn't have, that it's not the precedent for this case.
right. And I think it's important to note that this agreement did not waive any rights even under the HSCPA. The HSCPA specifically permits any other increases authorized by law. The legislature did not intend to invalidate prior administrative orders and allow tenants to come in and say that administrative order from 2006 cannot be enforced anymore. They specifically used the broadest possible language.
Using administrative order, how can administrative order be a law? That sounds different just by its terminology. An administrative order doesn't sound like a law.
Final administrative order, as in point 2 of our briefs, has the force of law and preclusive effect. It cannot be collaterally
You keep
attacked.
saying preclusive effect and collateral estoppel, but for collateral estoppel to be applied, isn't it undisputed that the party who you want to use collateral estoppel against was actually a party in that proceeding, and the tenant in this case was not a party to that agreement, and therefore you can't How can you use collateral estoppel
The
against?
distinction is, it's not collateral estoppel, it's collateral attack. Here, this is a summary proceeding. The civil court cannot collaterally attack and overrule a
Doesn't
final
he end up in
administrative
that
order.
apartment by virtue of the agreement?
Say that again, Your Honor?
Isn't he in that apartment by virtue of that agreement?
No, Your Honor, he's only in that, he's not a member of that agreement, he's only in that apartment as a successor to his deceased grandmother, and he's
Who had
seeking
the
a
apartment
windfall.
by virtue of that agreement?
No, Your Honor, he's
The
only,
grandmother didn't have the apartment?
grandmother was under that agreement, and she specifically agreed in that
And
agreement.
he's trying to succeed to her rights.
He has succeeded to her apartment, but he's not entitled to the rent that protected the Mitchell-Lama tenants. That's what DHCR ordered in 2006. Landlord could have taken those increases in 2006. It agreed to defer them until the Mitchell-Lama tenants vacated. And now the HSCPA doesn't waive that right. It specifically.
Thank you.
Thank you, Your Honor.
And we're familiar with the arguments and the briefs.
So, counsel, just on that point that your adversary seems to make about the administrative order having, as being authorized by law, that it is in fact law, what's your take on that?
That I have a couple of takes. First, the statute, when they're saying authorized by law, they mean statutory, other statutory within the rent stabilization code. So, for
Doesn't
example,
say by statute.
individual apartment, it says authorized by law. And so I think what the legislature was referring to is other increases provided within the rent stabilization scheme. So individual apartment improvements and major capital improvements, hardship applications that could be made. So that's what the legislator is referring to. Also, I do not think it is a final, just as a factual matter, not a final order. It was a settlement agreement that was effectively so ordered by DHCR. So that's different from if DHCR made a final order like on the merits.
Thank you. Thank you very much. Corbex Inc. versus NYC School Construction.
Good afternoon, Your Honors. Lita Ward from Welby, Brady, and Greenblatt on behalf of Corbex, the appellant. Respectfully, this court should vacate the lower court's judgment for the following reasons. There was never a denial of payment under Public Authorities Law 1744-2, Roman numeral 2, which requires the SEA to affirmatively deny payment. All there was a June 8th, 2021 letter directing mediation as well as referring this matter to the change order unit, which would not be.
Why couldn't that letter from, when was it? The June 8th. Why couldn't that be interpreted as a constructive denial?
I would say referring to a change order unit would
Because if you were
imply
gonna
that
pay-
they were.
If you were going to pay the request, why inform them of their option or their remedy of having mediation?
Well, I would say if it just said mediation, but it said mediation, and we are referring this to the change order unit, which presumably would be considering whether or not they were going to pay it, at least in part, subjective to the mediation.
That was my next question. So if the intent was to, maybe I'm not going to pay the exact amount that you're asking for, but would we be willing to consider something less, would that fall under, it's not a denial?
I would say it's not a denial at that point. There was an alternative date that was mentioned by the court, which was the service of the notice of claim. That date was June 22nd, 2021, which was within the one-year statute of limitation because the action was filed on June 21st, 2022. The court mentioned a date of June 17th, but that's not when it was served. Under the statute, it's service as for notice of claim being timely.
That's the date you're arguing applies, the date that the notice of claim was served.
I would say that was the court's alternative argument. I would say that it was never denied. It's not in the record because it was during mediation, but that's when there was an affirmative denial. We are not negotiating. Again, these are issues of fact, but
What date was that? What
Ma-
date
March-
was that?
March 30th, 2022 was when the mediation, Corbex was told through counsel, CSA's counsel, that they were not going to negotiate anything. and that would be the date of the triggering of the
Is there
statute of
anything which
limitations.
says whether mediation affects the running of the statute of limitations?
Can you repeat that? I'm sorry.
Is there anything which says whether mediation affects the running of the statute of limitations?
I wouldn't say there was case law on mediation.
Anything in the documents between the parties?
There isn't anything other than that there was a Teams invite by SCA saying this is the date of the mediation, which was March 30th, 2022, but there's nothing else in the record. May I continue?
Go ahead.
Okay. And as to what the court didn't consider but still summarily dismissed was based on documentary evidence. And I would submit the court never reached that issue, but there are clearly issues of fact. The SCA has not utterly refuted Corbex's claim that the $2.2 million.
There's a document schedule of values. There's a document schedule of values. What is that document?
I'm not sure, Your Honor. There were.
Isn't that the document which breaks down everything that's going to be done on the job? Breaking it out as to the cost and the labor? Is that what the schedule
That was
of
prepared by
values?
Corbex?
What's that?
That was prepared by Corbex?
Yes.
Yes. Yes.
There's no mention of terracotta in there, is there?
No. There was.
It's not a hostile question.
4 months after the 4 months after the contract was signed, they sent a extra, I would argue, extra work claim in the form of the specifications. There were several requests by Corbex about installation, and that is when SCA said, well, we're going to delete limestone and add terracotta. And by the way, here are 2 specifications for hand-pressed, one of 2 manufacturers, which the total cost was $2.2 million. There are other types of materials that could be used, which is limestone and extruded terracotta, which would be much, much cheaper. And so these additional specifications, which were submitted 4 months after bid, would be additional work. And
We're not making a decision on the merits here. We're just making a decision about whether there's an issue of fact as to whether or not it's.
right, and there's clearly issues of fact. And the judge never addressed any of that. I don't know if that had to do with not going beyond the statute of limitations issue, or if the court saw that there might be issues of fact and didn't want to reach that.
Thank you.
Thank you.
Good afternoon. May it please the court. Lauren O'Brien on behalf of the New York City School Construction
So you
Authority.
want us to use the date of June 17th, 2021, right? Rather than June 22nd, 2021.
So
Do we, in the law, do we compute statute of limitations, if you will, from when a document is signed or from when it's filed?
So I think the question, the ultimate question is whether the payment request was denied. And so our position is that the payment request was denied on June 8th when that email was sent, which was attached to the notice of claim. And at the very latest, it had to have been denied by June 17th, which is when Corbex swore to the fact that their payment request had been rejected and, again, attached that June 8th email. So based on the sworn statements from Corbex about when the underlying events occurred, the events underlying their claim occurred, the latest that they could have occurred is June 17th. We think it's clear, again, this happened on June 8th. And I think it's important that everything in the record indicates.
Mediation mean, though, we're going to see if we can work this out? How can something that says mediation is inherently something trying to resolve something? How can that be construed to be, as a matter of law, a denial of the claim? Because if you were denying the claim, you would say, we're not going to mediation, we're denying the claim. So why, as a matter of law, would that June 8th email letter constitute a denial?
So I think that the mention of mediation in the email is sort of irrelevant to the question of whether there was a denial. Under the contract.
Where does it say in that June 8th email, we are denying the claim?
So the email says that it was attaching the records of the back and forth between the agency and the contractor, in which the agency had repeatedly rejected the idea that the terracotta work was extra or was over and above the work
So what-
required under the
where's the
contract.
why wouldn't there be an express statement in that email? Then we are rejecting the claim. Where does that exist? Because then clearly you would be entitled to summary judgment because it's an express statement of denial. But looking through that letter, there's nothing there that says we are denying. And it's the opposite. Let's go mediate, which means let's try to resolve this.
So I think that the letter makes clear that the agency was not going to reconsider the contractor's request.
The language
How does it
that
make
makes
it
that
clear?
So it's saying you can, here's our
just
disputed
still
notice
went
of
to
direction.
mediation.
It's saying you have the option under the contract. There is a provision under the contract that says
Why
the
bring that
contractor
up
may.
if there's absolutely no ability to resolve this matter? If I knew I had no desire to settle a case with you, I wouldn't say, but hey, under the contract, you can go to mediation.
Well, here it's clear that the contractor did understand this to be a denial. It said in its complaint that its payment request was rejected by a letter on June 8th. It said in the notice of claim that the agency had rejected its payment offer. The agency had made clear that its participation in mediation was not a waiver of any rights or limitations under the contract, including a defense under the statute of limitations. That it specifically made clear it wasn't waiving those defenses by
But why doesn't
participating.
these varying possibilities create an issue of fact?
I think it's because there's simply nothing in the record. Everything in the record points to the fact that this was a denial and that the contractor understood that this was a denial. And
Again, I mean, we've been over it, but if it's a denial, why are you going to mediation?
I think that the statement in the letter that the contractor has the right to file for mediation is just a factual statement about the contractor's right under the
Even though there's no way we're doing anything for you.
So I think it was clear, and I think it's an important policy point and a reason why courts repeatedly say we aren't going to toll the statute of limitations when mediation is optional or voluntary.
This isn't about tolling, though. This is about this is not a tolling issue here.
But I think it goes to
cases
how
are
this
totally
court should
opposite.
understand the option of mediation. If the contractor
It doesn't toll, but it certainly does seem arguably an indication that you're willing to keep talking, that you haven't denied it.
I think that because of the contractor's admissions, it can argue that at that point it was confused about whether this was a
I just want
denial.
to ask you a question about demerits, which I know is not really the focus. But the schedule of values did not include terracotta. So how is it your position that it did include it, that it is included under the contract?
So I just want to clarify that the schedule of values that they refer to in their reply brief was sent not only after they submitted their bid for the contract and the bid was accepted and the contract
But didn't
was
it behoove
signed.
you at that point to say, hey, why aren't you mentioning terracotta in this document?
So it was also after the agency to, I apologize, I keep saying the agency, the contractor. It was, the contractor entered into the contract and only 2 months later asked for the terracotta specifications and at that point received them. So by the point that it was providing the schedule of values, there had already been a dialogue about the terracotta. And I think it's very notable.
Was that dialogue, we're denying it?
The dialogue was the contractor won the contract. 2 months later, it said, hey, we took a close look at this contract. We realized we need more information about the terracotta replacement requirement. Can you send us the specifications? And the agency, a few days later, sent them the specifications. So it's clear that the contractor knew immediately after having signed this contract, and nothing changed from the time that it submitted its bid to when it asked for the specifications. It knew that it was going to need some more specific details about the terracotta work.
Thank you.
Thank you very much.
Any dialogue between SCA and Corbex is not on the record. I would submit that it's issues of fact with regard to that. Also, there are, as I said, different types of materials, and even SCA said, oh, we are deleting limestone and adding terracotta, here are our specifications. This is 4 months later, they're changing their mind, deleting limestone where it doesn't even say limestone. It's understood in the industry that limestone would be a possible material for replacement. And there are, as I said, 2 different types of, this is like the Delrick versus SCA case in the sense of, you know, when you have specifications that aren't there and then they get added later, and it's much more time-intensive, money-intensive, that it becomes extra work. And there's at least issues of fact as it relates to that. I agree with your honors that this was not a tolling issue. There was no denial. There is nothing in the record that suggests there was a denial as per the statute. And just to add that the statute specifically...
Sentence, but your time is up. Just finish your sentence.
Oh, that the statute was amended in 2014 specifically because of cases with SCA not denying claims. That's why they had that specifically affirmatively added to the statute.
Thank you.
Thank you.
Mather versus HFZ Kick.
May it please the court, Nicholas Calabri with Omni Demirs McManus for the appellant Linder Griffith. In this case, the plaintiff was granted summary judgment under his labor law, section 241-6 cause of action, referring to the Industrial Code 23-9.4E. At the time of this incident, a excavator was moving a dumpster by pushing it ahead. The section of the Industrial Code that the court found...
And it was supposed to be rigged, was it not, and then lifted? Was that the way to do it?
The plaintiff's testimony was that the plan was to place rigging on it and move it 4 or 5 feet. There's testimony in the record that if you're moving a dumpster 4 or 5 feet, moving it with an excavator is normal and within the industry. But the code section that was found to be violated regards when a load is actually being attached and lifted, and the requirements of the section.
How could this not, the section refers to attachment of a load. How could this case, what's your argument that this case does not involve attachment of a load?
There was no attachment of anything to this excavator.
Counsel, in the Malloy case, didn't we have similar facts where there was supposed to be an attachment to the load, and because it wasn't attached, that was in fact the violation?
Well, in that case, it appears that they were lifting up a pipe with the teeth of a backhoe. So there was, again, lifting, and if you're going to lift something, the statute's very specific on how you have to do that.
So you're saying that because they were using this backhoe to push something, that's the difference, as
Correct.
opposed to lifting it, which maybe they would have done had they rigged it correctly?
Correct. There is no a mandate that you're not allowed to push anything with a excavator. The section, the Court of Appeals has held in St. Louis versus Town of Elba that the section was clearly drafted to reduce the threat posed by heavy materials falling from buckets by requiring loads to be fastened with sturdy wire proportionate to the weight of the load.
Doesn't the statute say any load handled by such equipment shall be suspended from a bucket or a bucket arm by means of a wire? It's very broad. So why wouldn't that language apply to the dumpster, that if you want to handle a load, you have to suspend it from a bucket or bucket arm by means of a wire?
Because the statute doesn't say that they have to do that. It says if you're going to lift something, these are the requirements.
It says any load handled by such equipment shall be suspended. It shall, and it says any load, if that equipment is going to handle a load, it has to be suspended from the bucket or bucket arm by means of a wire. It's very expansive.
But in the,
how do you get out of that broad
well,
language?
in the first line of Section E, it says attachment of load. There was no attachment of a load in this case. They were just pushing it. There's no prohibition to pushing something with an excavator.
Are you taking issue with the phrase "any load handled"? Is there any argument that the excavator here was not handling the dumpster?
It has to be read in context.
No, my
with
question is,
attachment of
was
a
the
load.
excavator handling the dumpster?
Was it handling it? Not in the statutory scheme here of attachment of a load. It wasn't handling it because it wasn't
You are focusing on the heading. I am focusing on what the actual subsection says. The subsection, as my colleague has read multiple times, says any load handled. My question to you is, when the excavator moved this extremely heavy dumpster with its bucket, was it handling that load?
It was moving it.
Okay.
I believe with the phrase attachment and handling the load that they're referring to lifting. And the Court of Appeals has said that's the clear meaning of the statute about lifting the load. The court also did not deny or dismiss the 23-9.5 section, which has 7 requirements. None of them pertain to the work that the plaintiff was doing in this case, and therefore that section should have been
Do
dismissed.
we have to figure out what the plaintiff was doing? Do we have enough information to determine what the plaintiff's role was on this particular work site?
We have enough information that we can go through every section of 9.5C and say he wasn't doing that.
I'm going to let you go further into that on rebuttal, and I'm sure your co-counsel will address it too. Thank you.
Good afternoon, Your Honors. May I please the court? Your Honor, the heart of the argument in this case is that the dumpsters are not the load here. The load may go into the dumpster, but the dumpsters are not load here. And I'm sure Your Honors have seen the video of the accident, of the incident, capturing it. It was and as Your Honor,
Why wasn't it the load? Because it didn't fit in the basket?
Your Honor, there was no attachment. The load is.
That's the very question. Should there have been an attachment? Because the excavator was moving this heavy object. And the whole point is to control the movement.
That's why the accident happened, because it wasn't attached, and therefore there wasn't the same level of control.
Your Honor, that's not the reason that the accident happened. The plaintiff categorically testified that when he spoke to the excavator operator and he was going back, he was pinched between the two dumpsters.
We saw the video, Counsel. I think we've all seen it.
Yes, Your Honor. It was.
Speaks to the person in the excavator, goes back the way he came. The excavator operator pushes the load right onto him.
Your Honor, the load is not the dumpster here. It was not the material handling.
You're saying that, but why isn't the load the dumpster?
Your Honor, because the load goes into the dumpster.
No, if you're using the excavator to move an object, even if that object doesn't fit into the basket, you're saying that that's not a load?
Your Honor, the dumpster was.
You're not questioning that the excavator was used to move the dumpster.
Yes, Your Honor, the excavator was used, but that was not the proximate cause of the plaintiff's accident. The plaintiff testified that the accident happened because the excavator operator was not paying attention. It was not because it was handling of a load that the accident happened.
The excavator's we're going around in circles, but if the excavator is moving the dumpster, that's what it's doing, then why isn't the dumpster the load for the excavator?
Your Honor, to answer that question, I just want to say that there was no material falling of any type of material that the Section 9.4E encompasses. It was not, the dumpster itself cannot be the load, Your Honor, because all the load.
So you're saying loads can only be things that go inside of other things? Is that your position?
Yes, Your Honor, that, and plus there was no attachment.
Is there a case law that says that?
You know, I do not have a case law on that point, but I just want to say that the provisions of Section 9.4E does not apply to the facts of this case, because the load.
How is this different than the Malloy case?
You know, in the Malloy case, the court did not say that Section 9.4E was violated or was the proximate cause of the plaintiff's accident. It was left to the question of fact, and it just reinstated that the denial of 241 subsection 6, but it did not say that the industrial code was violated in itself.
Thank you.
Good afternoon, Your Honors, and please the court. My name is Matthew Sakis. I'm for the plaintiff respondent. The appellants are urging the same argument to this court that they did to Judge Schumacher. They're saying that 9.4E only applies to loads that are actually being hoisted. Your Honors have pointed out that
Actually,
this
it speaks about material being handled.
Correct.
So if you're handling this dumpster by means of the hoe, that's handling the dumpster, that's handling a load.
I'm having deja vu from our oral argument with Judge Schumacher. That's exactly what he pointed out. He said when this point was raised by appellant's counsel, well, so isn't moving handling? So his actual quote was, so moving is not handling, question mark. And he said, and the regulation says nothing about being picked up. That's exactly
Doesn't use the word lifted.
I'm sorry?
It doesn't use the word lifted.
It does not. It says load being handled. The load here was the dumpster, as you pointed out, Judge Kern, and there's just no question that the applicability of this regulation was the proximate cause. We can all see it on the videotape where the excavator operator moves the load and it crushes Cody Mather up against the other excavator. What the defendants are really trying to do is create a perfectly circular argument. They're trying to say, well, the load can't be violated if it was never rigged. But the entire purpose, as Your Honor pointed out, of the regulation is to ensure that loads are properly handled by rigging them. Rigging is the key to the regulation. In addition, it has to be with a wire rope with a safety factor of 4, et cetera. But that's the point of the regulation. Also, another reason why this is a problematic interpretation that they're trying to have the court adopt is this is all territory covered by Labor Law 240. If their interpretation is correct, what's the point of this regulation at all? We all know about 240 and the protection for falling workers and objects. So again, this would be a completely superfluous way to interpret this regulation, to say, well, it only applies to loads that are being hoisted. It doesn't. It says very clearly, any load handled shall be suspended. You shall use rigging and move the thing safely. It's a lot easier to do it by yanking it, pushing it, whatever, but it's not the safe way to do it.
As you look at the video, had it been suspended, had it been lifted, probably this doesn't happen.
I absolutely agree, Your Honor. And I think at this point, I'll just leave, unless there's no more other questions, I think I'll just leave it at that, if that's okay.
Thank you.
Thank you very much.
Again, the purpose of Section 9.4E, it's a worker safety statute. So the redundancy, I don't understand. But again, the Court of Appeals has, in looking at this section, said it was clearly drafted to reduce the threat posed by heavy materials falling from buckets by requiring loads to be fastened with sturdy wire proportionate to the weight of the load. This statute does not mandate that any material must be lifted. It doesn't say that. It says if you're going to lift it, this is the way to do it. And therefore,
if you're going to handle it
by attachment of a load. I mean, the phraseology read together is talking about lifting something. You're having heavy ropes with safety factor of 4. Why are you doing that? Because you're lifting it off the ground. That's the reason that you need this sturdy rope. And therefore, I believe there should be reversal. Thank you.
Your Honor, the court's determination overlooks a critical fact that these are roll-up dumpsters equipped with wheels, enabling them to be rolled and maneuvered. In fact, it was a testimony of Lindy Griffith's owner that not all the time rigging is needed. These can be easily moved with the excavator, and there was no need of the rigging. And this testimony, Your Honor, highlights that the dumpsters have the inherent mobility and directly contradicts with any implication that manual lifting was required for this type of task to be performed.
Thank you.
Thank you, Your Honor.
The next case is People versus Dobson.
Good afternoon. Jonathan McCoy, Legal Aid Society, here today on behalf of Appellant Ms. Tawana Dobson. My argument today will focus on point 2 of Appellant's brief, the excessive sentencing point, and I will rely on the briefing for point 1. Ms. Dobson's case is an exemplar of a matter where this court should exercise its power to reduce her sentence to the legal minimum 5 years for 2 reasons. 1, Ms. Dobson's culpability was substantially and materially reduced by the severe mental illnesses she was suffering at the time of the crimes commission, which included persistent hallucinations and pervasive myriad delusions. The severe mental illness was compounded by the facts of her suffering from horrible trauma of diverse kinds from her childhood on, and also because of her moderate intellectual difficulties. Ms. Dobson's history of severe mental illness stretching back to...
Also, I don't remember. Can you just remind me, the 8-year sentence here, how did that come about?
That sentence came about as part of a negotiated plea.
It was a negotiated plea, okay.
Oh, sorry, I retract that. I'm sorry, that was mistaken. The court offered Ms. Dobson that plea.
The people were recommending 10, right?
Yes, Your Honor.
Okay, and the court offered 8.
Yes, Your Honor.
All right, and the court was fully aware of a lot of the arguments that you're making, right? There was a protracted history here where the defendant was 730, found unfit, institutionalized, and then eventually found fit, right?
Yes, Your Honor.
So a lot of the arguments that you're making were before the trial court, correct?
Yes, Your Honor.
So why should we do anything about it then?
Well, I would say first and foremost that this court's ability to exercise its discretion.
I agree, we have that power, but I'm asking you, why should we exercise it?
This court should exercise this power in this case because, based on the record, the only real aggravating factors that would weigh against the mitigating factors that are present here are Ms. Dobson's criminal history.
Which 2 felonies, right?
2 felonies.
And they were drug offenses.
Yes, Your Honor.
No arson, nothing violent.
No, Your Honor. And I would note that one of the first felony was committed in 1997. The second in 2000. This offense was committed 22 years later.
1997 YO for Rob 3.
She did, Your Honor. But to answer your question, was that?
Do you answer it?
Thank you. So the second reason why this court should exercise its power to reduce Ms. Dobson's sentence is because every moment she spends in prison beyond the legal minimum unduly exacerbates her existing mental illness, which was the root cause of this crimes commission in the first place. As this court recognized in People v. Sparks roughly a year ago, punishing someone suffering from delusions is unjust.
Did the defendant here reject an offer for some kind of insanity plea, and how should we view that?
She did reject an offer of a not guilty by reason of an insanity plea, but I would argue that that doesn't really affect the analysis of whether the sentence that was actually imposed was well tailored to her personal circumstances, and when weighed against the gravity of the offense, the manner in which it was committed, and the harm that was caused. The harm that was caused was some serious property damage, but I'll note that no one was seriously harmed, and I will also note that in contrast to, say, the facts in People v. Paulino, there's absolutely no indication.
I know that you stated that in your argument you want to address your second point,
yes.
But in your second point you're asking for reduction. In your first point, if you're successful, it's a reversal, right? So why don't you address the first point?
The reversal of the plea?
Yes.
It's our position that the inquiry that the court engaged in with Ms. Dobson about whether the fact that she was hearing voices at the time of the crime's commission.
Counsel, there's no doubt that throughout the history, the defendant had maintained that she was hearing voices.
Yes, Your Honor.
Right? At the sentencing, the court points out that the pre-sentence report says that she was hearing voices at the time that she set the mattress on fire.
Yes, Your Honor.
Right? And pursuant to that, in terms of an inquiry into that potential defense, the court asked just one question.
Yes, Your Honor.
And the question was, in sum and substance, do you understand that you're giving up this defense? The response was, mm-hmm.
Yes, Your Honor, that's
and the
correct.
court said, I'm taking that to mean yes.
Yes, Your Honor.
Was that sufficient?
I would argue that was not sufficient to apprise Ms. Dobson sufficiently that she actually had a defense based on the fact that she's hearing voices that would go to whether she had the requisite intent to commit the crime.
Did Ms. Dobson know this already? Because after all, the people were ready for a plea of not guilty by reason of insanity. And there was a discussion about it, and the defendant or defense counsel specifically rejected that offer. So the fact that the defendant was suffering from mental illness, and this comes up again at sentencing, this is something which the proceeding of this case had been over probably many times.
Yes, Your Honor. And even like with regard to the 730 order and examination, she was found not competent in trial, and after a year of inpatient hospitalization and medication by the Office of Mental Health, she was found competent, but notable, she was still suffering from the exact same kind of delusions she was suffering from at the time of the crime's commission.
But the defense made a conscious decision to walk away from that and instead take this plea.
Yes, Your Honor. I think it was reasonable for the defense to not enter into an NGRI, not guilty by reason of insanity plea, if only because of the indeterminate amount of time that...
So the reasonableness of defense counsel's decision not to enter that plea, that's neither here nor there as far as I'm concerned. The question is, at the time that the court was appraised of her possible defense, wasn't it incumbent upon the court to, at that time, inquire from the defendant if she understood the ramifications of that on that date? Not what happened the preceding year, not what happened the preceding 6 months, but on that date, does she understand the ramifications of her statement vis-a-vis her potential defense?
No, she does not, based on the record, I would argue, because simply stating to a defendant that you're giving up that defense with reference to the fact that she reported hearing voices does not actually interrogate...
Isn't that a statement that's made to most defendants and most allocutions that don't have mental illness? In other words,
that could be true, yes, Your Honor.
In other words, a defendant that's before you with clear mental illness, right? Because there's no question that this person has clear mental illness. Shouldn't the judge endeavor to make a more robust inquiry?
I would agree with that, especially when you're considering her moderate intellectual difficulties that are in the record, or reflected by the record.
Thank you.
Thank you.
Good afternoon. May it please the court, Faith Detrolio for the people.
So, counsel, just picking up on that last point, this case has quite a history where I think, as my colleague pointed out, everyone is aware that she had mental health issues. And so when we get this statement from the pre-sentence report that she was hearing voices at that time, is it sufficient really to just ask one question and then not even to get a positive or negative answer, because normally we don't accept mm-hms on the record, right? To then to say, I take that as a yes. Do we have that here?
Yes, Your Honor. So first I would say that the court had no duty to inquire based solely on the defendant's statement. But even assuming that, because the court didn't...
Wait a minute. Why would the court have no duty to inquire? The court was the one that brought it up. According to Dupree, if you bring it up, you have a duty to inquire. I was on Dupree.
So was I. Yes, Your Honor. Of course, prior to the court making that statement, it had no duty.
That's true.
Once it made that statement, it did have a duty.
Okay, perfect.
The inquiry in this case was sufficient for several reasons. One, the question was addressed directly to defendant.
Counsel, let me stop you for a moment. This is the question that the court says to the defendant with mentally ill issues. So with regard to the defense, I just have one question. In the INS, do we know if the defendant knows what an INS is? Ms. Dobson, it says that you claim that at the time of the incident, you were hearing voices. You understand that by pleading guilty, you give up the right to raise that as a defense. Do you understand?
Yes.
She says, and it's over. And you think that's sufficient for someone with a history of mental illness?
Yes, Your Honor. So I would argue that the question made clear that defendants claim that she was hearing voices was a potential defense that she could have raised at trial. It made clear that she was giving up that defense by pleading guilty, and defendant's answer made clear that she understood that she was doing so. That I would argue that that's an answer in the affirmative.
All of this had been discussed during the appearances on this case and before the plea was taken, was it not?
Yes, Your Honor.
So what is a judge's obligation then at sentence? This comes up at sentence. What is a judge's obligation at sentence where these issues, it comes as no surprise that she's hearing voices. Everyone knew that she'd been hearing voices. What is the judge's obligation at sentence in order to impose sentence?
So I think, as we discussed, under Dupree, because the court brought it up, then the court had a duty to inquire further. But I
The
think
fact that the court brought it up means it meant something to the court, because the court could have remained silent and then had no duty.
And we wouldn't be here.
Sure, Your Honor, but I think that in the context of this case, that this was an issue that everyone was aware of. I think it was, important for the court and to.
And counsel, I don't mean to interrupt you, but I just want to make clear. So throughout the course of the case, it's clear that the defendant had maintained that she was hearing voices. Right. Did she ever specify before the pre-sentence report that she was hearing voices at the time she set the mattress on fire?
Yes, Your Honor. I believe she did. I believe it was either the 7:30 report or one of the psychiatric reports. She said that the voices got the best of her on that day, the day of the incident. So this was, something that everyone who was involved in the case was aware of.
It seems to me, counsel, that the argument is that because this was the running theme of this case, right? Mental illness. She said before she's hearing cases that because of that, the judge is relieved of the burden to follow up on an issue that the judge brought up, right? As opposed to the opposite, which would be because this case involves mental illness and because we want to dot our I's and cross our T's, maybe I need to ask you more questions and maybe I need a response other than,
Sure, Your Honor. I would just say a few things. One is that, this is at a time that defendant was found fit to proceed. So she's able to, understand.
Counsel, I want to stop you.
Okay.
On April 20th, 2023, OMH said she was fit to proceed. The report noted that she still heard voices a lot and was on 3 psychiatric medications for mood and psychosis and continued to have delusions related to Cardi B.
2 things, Your Honor. One, defendant said that her medication was not affecting her ability to understand the proceedings, and I think counsel also confirmed that he was certain that she was understanding the proceedings. And the second thing I would say is that although she may be hearing voices, that's not being found fit to proceed is not necessarily saying that she is necessarily able to understand.
that her mental issues are gone, right? That her mental health issues are gone.
When
sorry?
clearly on May 23rd, sorry to interrupt you, on May 23rd, Cases sends a letter to the court saying, we think she should be in treatment, not incarcerated. And then on May 29th, the social worker in the Legal Aid Society says, we believe she needs to be in long-term residential treatment based on her mental illness. On October 2nd, she takes a plea. On October 27th, she says, I set my bed on fire, I was listening to the voices. And on October 30th, she's sentenced. And all along, she's mentally ill, but that one question and the is sufficient.
Well, the one thing I would say about the question is that it is correct. That is a defense she could have used at trial. And I know counsel, discusses the difference between an ordinary defense versus an affirmative defense in this case. But actually, I think this question is suitable for a defendant because it's maybe a simpler version.
It seems like the defense was determined to avoid and not guilty by reason of insanity.
That's correct, Your Honor. It seems that, at all stages of this case that she did not want to engage.
Whatever defense is trying to avoid does not relieve the judge of his duty.
No, Your Honor.
Ask further questions.
No,
He asks 2 or 3 more questions, we will probably be okay.
But I would argue that this case is sufficient in this case, given the overall context. And
So let me ask you a question because it hasn't been addressed. So your adversary opened up on reduction.
yes.
What's your position on reduction?
So I would argue that
In light of in light of what we already know, right? Severe mental illness, the history is the criminal history is not violent, with the exception of the YO maybe, which I don't know that we should consider. But there we have it. What's your position?
So defendant's sentence in this case is fair and appropriate, especially given the very, very serious nature of this crime.
But it undoubtedly was serious.
Very
right? But
serious.
there was no one hurt.
Luckily, no one was hurt, but as the judge said at sentencing, this could have been a very different situation. Defendant fled the building and then called 911 several minutes later. There was elderly and young tenants in the building.
More of a reason for the judge to done more questioning, correct?
No, Your
Instead
Honor.
of the just a
Your Honor, I would argue that that is an affirmative response. But about the sentence, all of the purportedly mitigating factors were considered by the sentencing court. This court says that at the plea, we've been over this time and time again. I've read everything you filed, and those were the psychiatric reports indicating. Thank you.
I'll be brief. I would just like to point out, excuse me, 1 second. Point out Chief Justice Wilson's opinion, concurring opinion in People v. Green from last year. I won't recite what he says on the record, but I imagine this panel is familiar with what he said or can refer to it. But the only other point I would like to make is that there is no evidence from the record in this case that Ms. Dobson had any malicious, vicious, evil, or otherwise socially harmful motives when she committed this offense. In fact, it's questionable whether she actually knew that she was setting anything on fire at all. That said,
Why'd you call 911 and blame it on her boyfriend?
I would say that she called 911 after leaving the apartment building, recognizing, as she stated in her and during her interviews with Fifth Avenue Forensics, that that she left the apartment because she thought that the voices outside were calling out for her, and then once she left the apartment, she thought and realized that she may not have flicked her cigarette outside, but it may have fallen inside, and that upon that realization, she called 911. Now, with regards to the boyfriend, I would point to the fact that Ms. Dobson, at this time, was severely delusional. And looking back at the record of her interactions, her interview with the fire marshal, that question is brought up, where's your boyfriend? And she's obviously, clearly confused about the issue of whether she has a boyfriend or not. So with that, I will rest the case. Thank you.
DeFrancesco versus McEnroy.
Good afternoon. May it please the court. My name is Martin Kreslik. I'm here on behalf of Appellant Connor McEnroy. Your Honors, this is not the first time that an ex-spouse has tried to retrade on a years-old separation agreement. Because there have been so many cases, the law is well developed. Separation agreements are final and should not be disturbed. Now, 5 of the 6 causes of action in this case were dismissed under the ratification doctrine. And that doctrine provides—
a very specific question, which is the obligation under the agreement to set up a trust, which has undisputedly never happened. What should be the result of that? Because that's obviously a breach of the agreement, since the agreement required that a trust be set up. So how should we as this court handle that issue?
Well, I think Ms. DeFrancesco chose the wrong remedy. She chose to throw out the entire agreement and rescind it. Is there a remedy? Yes. She could have sent a notice of default under Article 16 of the agreement, offering Mr. McEnroy an opportunity to cure.
So are you basically conceding that she does have the right to specific performance of that obligation to create a trust under the agreement?
Ms. DeFrancesco absolutely has a right to have that trust created. However—
But she brought the wrong cause of action?
No, not just that. The separation agreement makes clear that Mr. McEnroy has control, full discretion over the details of how that fund is to be created.
Doesn't it say that he must create that trust within 5 years? And isn't it undisputed that there's been a breach of that obligation to create the trust? However he does it?
Well, first of all, there's a factual issue about why the trust did not come into existence. It is Ms. DeFrancesco's fault that the trust doesn't exist today. Mr. McElroy was ready to fund the trust long before the 5-year deadline expired. And there's evidence in the record, there are communications between Mr. McElroy and Ms. DeFrancesco about that.
But that would all come out if she had in fact filed and sought the right remedy.
Correct, she did not seek the right remedy. What she
Do you oppose a motion on her part to amend the complaint, to assert a cause of action for specific performance of that obligation?
I
I mean, I know that's a weird question.
Well, I think we do. I think we have some election of remedies issues here. Remember, there are 6 causes of action.
Could she tomorrow start a new action for specific performance?
She could potentially start an action for specific performance on the narrow issue of the establishment of the trust. But
Which
again,
was supposed to be done within 5 years, and it's undisputed that 5 years have passed and the trust has not been established.
that is correct. That is correct. However,
We'll let you argue about the case now.
okay, thank you.
Because obviously that's not the issue before us, but we had questions about
No,
it.
and these
Although
are-
it is an argument for why there's a default under the agreement, which would give her, she's arguing it gives her the right. So what's wrong with that argument? Why isn't she entitled to the confession of judgment based on her argument that there's been a breach of the agreement as a result of the failure to set up the trust? What's wrong with that argument?
Well, okay, if I'd be happy to move to the first cause of action. I was addressing the ratification doctrine, which is causes 2 through 6.
Right, no, but that's what
Right.
I want to ask you about.
Right. So with respect to the first cause of action, the document that was filed prematurely. So that document has 2 paragraphs that are applicable here, paragraph 3 and paragraph 5. And according to the lower court, there's tension between the 2. So according to paragraph 5, which makes clear that that affidavit must be accompanied by an affidavit by Ms. DeFrancesco alleging to missed payments. The default is missed spousal payments, not the establishment of a trust. The establishment of a trust is not a default. It may be a breach, as Your Honor put it, but it's not a default under the agreement. So did she have a cause of action for breach of the separation agreement? Perhaps, but that's not what she filed. She filed an action to set aside, to throw out the separation agreement. And I can't see how she can go back now and change her entire theory and file a cause of action for specific performance of the agreement that she claims should have been rescinded.
Why can't you do that?
Well, because of the election of remedies doctrine. But the direct answer to your question, Your Honor, is that Mr. McElroy has no issue with the establishment of the trust. He's been trying to do so. So any remedy that establishes the trust is a remedy that Mr. McElroy can and is willing to accept. The issues that we've been quibbling about are the details as to who has what rights with respect to the details. She claims it has to be in Peru. Not so. If you look at the separation agreement, it makes clear that Mr. McElroy has discretion with respect to the location.
Okay, for the last, so you're saying there's disputes about how, but for the last very little time we have left, do you want to quickly address the ratification?
Yeah, the ratification, I think it's clear from the papers. And in Stackholm v. Wunsch, this court made clear that this issue can be decided on a motion to dismiss when it's clear from the papers. And here, Judge Frank correctly held that it is clear from the papers. She accepted the benefits of the agreement for over 6 years, $15,000 a month in spousal payments, $1 million lump sum payment, the properties that were given to her. So she claims that there was duress, that this was unconscionable, but it doesn't add up. What's unconscionable about those kinds of benefits? In any world, those are substantial benefits. And there's no doubt, she admits that she received and keeps receiving, as of today, $15,000 a month and will continue to do so until she dies.
I know your time is up, but very quickly. It almost sounds like you wouldn't have a problem if we ordered that the trust be set up. But then on the other hand, you're saying that there are a lot of issues in setting up the trust that remain unresolved.
That's correct, Your Honor. I think that these issues can be settled between the parties privately, but there is absolutely no issue on my client's part to set up the trust.
Thank you.
May it please the court, I'm Joy Frank. I represent the respondent and cross-appellant, the wife, Daniela DiFrancesco.
What's wrong with the ratification argument that she accepted the benefits under the agreement for 6 years? She got that, she argues she didn't, but she got the houses, she got the distributive award. Why hasn't she, at this point, ratified the agreement as a matter of law, prohibiting her from now challenging it?
Because the ratification doctrine doesn't apply here. She hasn't received the key benefits of the agreement. She hasn't received the trust.
Hasn't she received the $15,000 every month? Hasn't she received a distributive award?
Yes, she has. But under the agreement, the trust was to be created within 5 years.
Wasn't the trust to be created to secure his obligations to pay the distributive award, and hasn't he been paying those?
Yes, he has, and that was the amount. However, the key benefit here is that it was security for her lifetime spousal support. Without it, he is an international businessman. She doesn't have any financial disclosure. So she's basically at his mercy for every month's payment.
You didn't actually bring a specific performance claim to compel, and then we looked for that. There is no specific performance claim to compel the execution of a trust. Instead, you're trying to get at the confession of judgment. But isn't the remedy that you should be seeking here, since the trust has not been established, to seek specific performance for the execution of the trust?
I think there's a lot of interwoven issues here, and the confession of judgment is intertwined with the stipulation of settlement. So in the first cause of action,
usually put into place because it's in the event that there is a default in the payment, you or your client would then have the right to execute on the confession of judgment based on a default in the payments made, and actually makes a reference in that to listing the payments made. But it's undisputed that there's been no default in this case. So how do we handle that?
but could I direct the court to the verified complaint, the first cause of action? It may be not entitled specific performance. However, the allegations specifically state that he has failed to perform under the agreement, and then the confession of judgment is the evidence of the damages.
All right, but if the failure to perform under the agreement is the failure to set up the trust, what you need to connect up is why is the remedy for that not specific performance compelling him to set up a trust, but instead allowing your client to execute on the confession of judgment? What's the rationale for that?
Well, the lower court dismissed the causes of action based on ratification and the waiver of financial disclosure. The court didn't have any issue with the first cause of action, which it sustained. It
Right,
found-
but the husband is appealing that, so it is before us, and we have to determine whether or not the court was correct or not. So we do have to decide that issue.
May I please refer the court to the language of the verified complaint in the first cause of action, where it may not be titled specific performance, but our position is that we put in the language, all the allegations and the language to indicate that this is a failure of performance. And as we noted, we also filed an application to amend the complaint, but it never got to the point. The court didn't address in its decision whether or not that issue of amending the complaint. But we do have a
But I'm
right
sorry,
to
the court never
make a motion.
decided. The court never decided your motion to amend the complaint?
There was no motion before the court, but in the opposition to the motion to dismiss, there was a request to amend the complaint if necessary, but that was, it was dismissed before that took place. We could, according to the CPLR, I believe we still have the time to move to amend the pleadings if necessary.
You could go ahead now and amend the complaint to specifically assert a claim for creation of the trust.
Correct, Your Honor, yes.
Okay. Sounds like that could be a good option.
A point well noted, thank you. But to continue, our appeal, our cross appeal, is based on the fact that the ratification doctrine was used to sweep away the second and through the 6 causes of action. We believe that doesn't apply here because she hasn't received the key benefits. You cannot ratify an agreement where you haven't
Aside from the
received the
trust,
key.
the trust was not created. What key benefit did she not receive?
She was to receive from the husband the marital residence in Lima, Peru, which has been her primary residence for years. She's living there now, but she doesn't have sole title to the property, which is what she was supposed to receive. And under the agreement, the husband was obligated to hire the lawyers and to effectuate transfer. And he has not done so. He attempts to blame her for not doing it by not signing powers of attorneys, but there's nothing in the record where he's made any request for her to do that. And in fact, she hired counsel in Peru who says the problem with the agreement, the mistakes and errors in the agreement that were rushed. This was a rushed signing of an agreement in one session, in 1 hour, where she was to absorb 38
Was
pages.
she represented by counsel at that proceeding?
She was, Your Honor, counsel who she had met once prior for an hour, and the second time she met him, the third time she met him was for the signing. And this entire, with the size of this marital estate, this divorce was resolved within 3 weeks. So this is a very unique
That she didn't
case.
receive the substantial benefits of the agreement. We understand
Correct,
your argument.
yes.
We have it. Thank you.
Yes, thank you. Thanks, Your Honor.
Your Honor,
Can you respond to this point about her residence in Peru, that she hasn't received title to it and she was supposed to?
yes, Your Honor, she has been living in that property for over 20 years. The property is currently titled to both Mr. McElroy and Ms. DiFrancesco. The settlement agreement does not have to be reformed for that transfer to happen. All that has to happen is that parties have to sign powers of attorney, because she has to do the same for him. She has to ensure that certain properties are transferred to him. She refused to do so, so he did not do the same. He stands ready to do so, and Ms. DiFrancesco knows it. That was communicated to her counsel many times.
He hasn't brought any action saying that she hasn't done anything, right?
No.
Or this is her
No.
saying that he hasn't completed what he was supposed to do.
No, he has not brought any actions against her. With respect to the shifting theory that her first cause of action can be read as specific performance, well, that's just nonsense. I mean, it says judgment on the defendant's confession of judgment. It makes clear that she's asking for a $3 million judgment. And the last thing I want to leave with, Your Honor, is that CPLR 3218 makes clear that she can't file that confession of judgment because 3 years have passed. That there's a 3-year limit on filing a confession, so she cannot file that as a matter of law, which is why she's shifting her theories.
Thank you.
Thank you.
Brahma versus 230 Paz.
May it please the court, Your Honors, David Holland. I'm from the law office of Nicole Lesperance. I'm here today on behalf of the defendant, Appellant Reedy. As the court is no doubt aware, this case involves a fall on a public sidewalk adjacent to a building that is owned by and occupied by the respondents here today. It's a public sidewalk. There was initially an allegation in plaintiff's complaint and bill of particulars that he was riding a scooter and that he was caused to fall from the scooter because of a defect in the sidewalk. There's no allegation in either the notice of claim to the city, in the plaintiff's complaint against Reedy, or in his bill of particulars to Reedy that involved anything other than a defect in the sidewalk. There's no mention of lighting anywhere.
There's also been no depositions.
That's correct, Your Honor. That's correct, Your Honor.
So has plaintiff ever had an opportunity to be asked that question? Was there anything wrong with the lighting at that point? Has she been, other than at the 50H hearing, has there been a deposition at which the defendants were present where they had an opportunity to question her about the lighting?
Your Honor, if he had alleged it in his complaint or his bill of particulars, but the
But they haven't had the opportunity to actually directly ask her that. Because are they making a claim for contributory negligence?
They are.
So
that's all that's left at this point.
I'm sorry, what?
That's all that's left at this point. The plaintiff
Right, so if
did
they're
not
arguing
oppose.
contributory negligence, they would have the burden to show that your client was somehow responsible. So aren't they allowed to develop an evidentiary record that would support their claim that there was some negligence on your part of your client, lack of lighting, that somehow contributed to the accident to support their contributory negligence?
It was actually addressed on the motion below, Your Honor, because the initial motion was made, there was no rebuttal with respect to the lighting because it hadn't been raised by anybody yet. Reedy had no reason to even put in proof with respect to the lighting. It was raised only by, the plaintiff did not oppose the motion. It was raised by the respondents here today. And in Reedy's reply, they attached an affidavit of someone who was on site, as well as a summons from the city regarding improper
You know,
lighting.
I'm
on the
familiar with all
scaffold.
that and that it was repaired, but that all came up in reply. So again, where did they have the, if they have the burden of proof to show some contributory negligence on your client's part to prove their claim, where did they have the opportunity to rebut that if it only came out in the reply page?
I understand what you're saying, Your Honor, but what we're talking about here is the classic case of depositions that haven't been done yet, and they have to offer more than just surmise and conjecture that maybe it
Right,
was
but we
related to
don't
lighting.
normally, especially in negligence cases, we don't normally grant summary judgment before there's been any discovery on those issues. I mean, that's the more unusual.
Yes, I would point out, Your Honor, that
No one ever mentioned lighting as an issue here.
correct. It was never mentioned by plaintiff, and plaintiff didn't oppose the motion below. One would think that if lighting was involved, he would have amended his bill of particulars and put in opposition to the
What's your
motion.
position? I guess I still haven't really heard what your response is to my question about why don't they have the right to develop that argument as part of their contributory negligence claim?
I guess, Your Honor,
I mean,
that
if the jury
yeah.
hears that it's totally dark underneath there,
right.
why
Well,
wouldn't that influence a
yeah.
jury's ability about how to apportion
I mean,
fault?
we do know that it happened on a clear day at noon also. So this is not like a nighttime accident.
What time did it happen?
It happened at noon on a clear day. There's not even a culpable, there's not even a shadow of an allegation that lighting had anything to do with this. So as I said, that Reedy had no reason to address this to me when they made their prima facie case. It was only after they raised it, and we would submit that it's a feigned issue of fact. The plaintiff is the only one who knows how this accident happened. He's never alleged it. He's never alleged in his complaint or his bill of particulars. Thank you, Your Honors.
Good afternoon, Your Honors, and may it please the court, Ross Frisha for the respondent owner. I think
So how are you going to address that issue about that there's no allegation by the plaintiff that lighting had anything to do with it, and they gave in repair records? So based on that, why should we let that claim go forward?
well, for a couple of reasons, Your Honor. First, the evidence of the repairs were submitted on reply, and we, like you said, the respondent here hasn't had the opportunity to rebut that evidence. And I think Your Honors hit it on the head when, you know, this motion is premature.
This noontime fall involved a lighting problem?
I'm sorry, Your Honor?
This noontime fall involved a lighting problem?
Yes, Your Honor. And you know what? If you're going at noontime, let's say it's a bright sunny day like it's supposedly here, and again, we haven't had the opportunity to question the plaintiff.
If we were
as to
here with the plaintiff now saying that, in fact, the accident happened because of inadequate lighting, we'd be talking about, well, that's a new theory that wasn't alleged. And we'd be wondering whether or not we could actually allow that to go forward. So where there has been no allegation of lighting, why can you just bring that out of nowhere?
Yeah, so, Your Honor, first let me finish answering your question, and that's basically if there is an inadequate lighting under a shed, even on a sunny day, your eyes need to adjust when you go under the shed. So there's a possibility that that could have influenced his fall or his maneuver or his direction. And to answer your question, Your Honor.
This was an open scaffold, wasn't it?
Yes, Your Honor. So to answer Your Honor's question about the theory of liability, he wasn't asked that at the 50H hearing. Number one, if you can even rely on that, because a 50H hearings is not admissible against the respondent here.
But he also didn't put it in his complaint or in the bill of particulars. It's not there.
The contractor was sued in this case, and as a co-defendant here, we have
Talking about Arsenal?
I'm sorry?
Which contractor?
Reedy. Yeah, Arsenal
is out.
Yeah, but in this case, you know, the plaintiff was only asked, you know, what happened, and he said as he was going forward, the wheel of his scooter got caught in the crack, but he was never asked, is that the sole cause of the accident? He was never asked about the circumstances attendant to that accident, and to dismiss this case at this stage, which was pre-deposition and pre-discovery, would infringe on our right to seek a contributory claim against the co-defendant. So this just wasn't fleshed out at all yet, and quite honestly, it's a due process issue, if you ask me. We have case law here that dictates that the presence of a scaffold imparts a duty onto the person who put up the scaffold to provide a safe walkway under the shed for pedestrians. We don't know if that scaffold influenced in any manner how the plaintiff traversed the sidewalk, and it's quite honestly unfair to just throw the case out without having at least the opportunity to question the plaintiff on that issue. And if there are no further questions, I will rely on my brief.
Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. Guy DeRosier, Wilson Elser for Respondent JP Morgan Chase. I'll be very brief. I don't want to repeat anything that's been mentioned already, but I just wanted to add that the repair records, not only were they submitted on reply, and I understand Appellant's argument as to why they were submitted on reply, but the repair records were not really authenticated. They came up, there's an email, there's something, an affidavit from the person, the contractor that was apparently hired to make the repairs, but none of this came in through a person who was able to say, well, where did these documents come from? How did they know about them? It would just kind of came in through counsel's affirmation. And so we ought to at least get discovery. It's not speculative to say there was a lighting problem at some point close to the time.
I'm sure at night there was a lighting problem, and that's probably why there was a violation, but it's hard to think that at noontime there was a lighting problem.
Well, as my colleague
said. And an open scaffold.
Well, these are issues of fact, and we ought to...
I see you chuckling, and it's understandable.
Well, it's an issue of fact. I mean, if it was a bright, sunny day, it is possible that as you go, this person was on a scooter. We don't know exactly how fast he was going. He was on the sidewalk on a scooter, and he went from possibly a sunny area into directly into underneath a scaffold. May have been an open scaffold, but his eyes may have needed time to adjust. If there was not proper lighting under the scaffold, that may have contributed to the happening of the accident. Unfortunately, I don't have more than that to go on.
I mean, the lighting that's required for the scaffold is required for a bright, sunny day for someone walking from the street onto the scaffold, and the purpose of the lighting isn't to provide illumination at night. That's what you're asking us to believe.
Well,
or accept.
I'm simply stating that there are issues of fact here that need to be explored. There's also one other issue that wasn't explored, if I may, just for 30 seconds more.
Very brief.
Very briefly. If you look at the photograph on page 253 of the record, there was something in the notice of claim saying that essentially there was a missing pedestrian ramp. The city didn't ask any questions at the 50H hearing as to whether this so-called missing pedestrian ramp had anything to do with this accident. But the plaintiff did testify at the 50H hearing that he was apparently heading right for an area of the sidewalk where apparently there is no pedestrian ramp. And if you look just to the left of that, there was a piece of the scaffold footing that's right next to the area where the pedestrian ramp was. So whether or not the scaffold may have played some part, or the placement of the scaffold, lighting or whatnot, in the happening of the accident is still entirely to be developed through discovery.
Thank you.
Thank you, Your Honors.
Your Honors, I'll rely on my initial argument and my brief unless there's any other questions.
Thank you.
Thank you.
Ramirez versus Texera Bakery.
May it please the court, my name is Dan Ratner. I represent the plaintiff on this appeal. This appeal involves a choice of law issue arising from an accident on the Harlem River Drive, a stolen truck that struck my client, who's a New York resident, who was working on the road at that time. The defendants are the owner and the operator of that truck that was stolen in New Jersey on the other side of the George Washington Bridge.
And isn't that where defendants' involvement really ends at that point?
Yes, except that, well, I would just like to put a caveat on that. He was on his way into New York when the truck was stolen. He had a bakery delivery, a baked goods delivery route.
The conduct that's at issue here, leaving the key in the ignition and leaving the truck unattended, that's conduct that happened totally in New Jersey.
Right, but that doesn't completely solve the riddle when it comes to choice of law.
But in terms of when you have a choice of law and what you're seeking to, and when the aim is to regulate conduct, it would make sense to apply the law of the jurisdiction where the conduct occurred.
Well, that's what this court discussed in the El Maliak case, which is cited in my brief. Ultimately, you have to decide where the injury occurred. The locus is equivalent to where the injury occurred. That's when the tort is actually happens, where the injury occurs. So you can have an act in one place and the resulting injury in another. So in the El Maliak,
When you look to where the act which created the liability occurred, isn't that the standard when it's conduct regulating as opposed to the injury?
That's not
Because
my-
it's conduct regulating, you want to look at where that conduct occurred, which makes sense. So if we're looking at where the conduct occurred, why wouldn't that be New Jersey? Because that was the last act that the defendant potentially did, which could make the defendant liable.
In the El Maliak case, which involved terrorism, explosions in Israel, the conduct at issue in that case was bank transfers here in New York. And this court held that because the plaintiffs were injured in Israel, that's where Israeli law, Israeli substantive law, conduct regulating law would apply. That's what the court held. This case is no different. It really isn't. You have parties from different domiciles, conduct occurring in one place, an injury occurring in the other, and the
These
tiebreaker.
cases, I mean, Schultz is a court of appeals, and I don't think it talks about, which is dispositive for us, where the injury occurs as being the standard to apply in these cases.
Well, in fact, if you read the quote in Schultz, and by the way, factually, Schultz is different because in Schultz you had people, the domiciles were the same. Everyone was
No,
from
but
New
I'm
Jersey.
talking about the law in Schultz, which says you look to where the last act occurred, not where the injury occurred.
Well, if I can read from Schultz at 65 New York 2nd 195, yes, the first part of the quote is that you look to the place where the last event necessary to make the act reliable occurred. Granted, that would be, in this case, that would be New Jersey, right? The last
That would
act.
be New Jersey.
Right, but the next sentence, it says, thus the locus in the case is determined by where the plaintiff's injuries occurred. That's what it says, and it's the tiebreaker. And these cases are not easy, Judge, I understand that. But the tiebreaker is where the injury occurs. And why? Well, because that's where the jurisdiction has the greatest interest in protecting the
Then
injured.
why would you talk about where the last act occurred? You're basically writing out that part of the standard. It's meaningless. If it's just the injury, why do you have to do any inquiry? You always know where someone was injured.
Well, I think the problem is that when you have,
You're saying the law is inconsistent?
no,
Is that your argument?
not at all. I'm saying this is what
Then
the
how
law.
do we interpret all the cases that say that you look where the last act occurred that created liability? If you just simply look at where the injury occurred, that those cases and those holdings would be meaningless, wouldn't they?
Well, I think this court in El Maliak did not say that. It specifically said we look to where the injury occurred. I mean, that's what the case law says. Now, Schultz was factually different. And so if the court is going to rely on Schultz, the problem there was that there you had two everyone was from New Jersey. And almost all of the acts, all of the tortious acts, the sexual abuse, occurred in New Jersey. And the only reason why the court didn't apply New York law in that case is because it was sort of coincidental or it's just a side issue because some of the abuse occurred in New York.
Thank you. Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court, Irina Kravchenko, I represent respondents appellants on this appeal. It is their contention that the Supreme Court correctly performed the choice of law analysis and applied New Jersey law to this conduct regulating law of vehicular theft. The Court of Appeals, as the panel has pointed out, has repeatedly and expressly stated that the test is the interest analysis that takes into consideration where the tort occurred, because the state where the tort occurred has the biggest interest in regulating conduct within its borders, and it has the biggest interest in protecting people that act within the borders of that state. So taking into consideration the overarching standard of the interest analysis and the tort, and the every single contact that is relevant to the particular tort at issue, which is theft, all of those things took place in New Jersey. Plaintiff is asking this court to enforce a vehicle and traffic law of New York upon a New Jersey resident whose car was stolen in New Jersey while he was working for New Jersey at a New Jersey company, and every single fact that has to do with the theft and with the vehicle aspect of it, everything took place in New Jersey. So we respectfully ask the court to affirm on that issue, and if you don't have any questions, I'll rest on my brief.
Thank you.
Thank you.
In the El Malia cases, this court specifically stated at page 516 of the decision, we hold that Israel, the location of the plaintiff's injuries, has the greater interest in seeing its laws enforced, and Israeli law should govern this action. It's the tiebreaker, Your Honor. When there are varying interests, people from different domiciles, the tiebreaker is where the place of the injury occurred. So here you have a situation in which a business that availed itself of New York commerce, right, allowed its truck to be stolen right over the border as the truck was on its way into New York to conduct business, and the truck struck a New York resident who was working on a New York road under a contract with the state of New York at that time. There's a reason why there's a vehicle and traffic law in New York that deals with allowing unattended vehicles, because other places have held that the misuse by a thief sort of breaks a causal chain. But this state does not have that law. It protects New York citizens from that type of thing.
Thank you.
Thank you, Your Honor.
Your Honors, I will waive rebuttal.
People versus Moore.
Your Honors, and may it please...
Give me one moment, I'm sorry.
My apologies.
It's not very often we see you on that side.
Hmm?
It's not very often we see you on that side.
It is not. It is strange.
Okay, go ahead. Thank you.
Your Honors, and may it please the Court, Anna Notchik for the people. The New York State Legislature has mandated that some convicted felons receive higher sentences when they have certain predicate convictions. In this case, relying on Erlinger v. United States, Justice Merchan declined to make factual findings regarding tolling.
I'm going to interrupt for a second, because the very first question I think that we need to address is whether we should get to the merits of the Erlanger argument in this particular case, whether this is appropriate case to do so, since there's clearly a strong preservation argument against the people with respect to this argument. So why don't you address that first?
Your Honor, I disagree that there is a strong preservation argument. I think the people clearly preserve this issue. The people wrote a letter to the court saying Erlinger may not apply here, cited to Justice Wiley's decision finding that Erlinger did not apply.
Wait, didn't the people actually ask, in the interest, I don't have the exact language, but for a jury to be impaneled because they weren't willing to make the argument to the court that Erlanger did not apply, and they therefore requested either the impanelment of a jury or that they go with the sentencing which occurred here, which was the second violent felony offender, in effect giving up on any argument that no jury was required. So since they never made, the people never really made the argument below, they basically conceded it for purposes of their requesting an impanelment of a jury, why should we address it now?
Your Honor, I don't think the people conceded it below. I think the people made three alternative arguments. The first was to impanel a jury. That is clear and the people made that argument because that would clearly comply with Erlinger. The second argument the people made was that Erlinger may not apply. It's right there in the letter. And the people cited to Justice Wiley's decision.
So is it, what is the people's position then that, because if you want the panel, then you're saying that Erlinger applies, or is the
Your Honor, the people's position was just that the easiest solution, the natural solution here, would be to just impanel a jury. Because if Erlinger did apply, that would obviate any Erlinger concerns.
Right, but then you didn't go into substance as to whether Erlinger applies.
We did, Your Honor.
So in fact, what happened was because I have the letter here in front, and it does say that it says, although there is an argument that Erlinger's holding does not apply here at all, the people continue to recommend in an excess of caution that this court exercise its inherent power to convene a jury to determine the defendant's predicate status. The next paragraph says, alternatively, this court should sentence defendant as a second violent felony offender. So while you pointed out the issue that your position, or there may be an argument that Erlinger does not apply, you moved forward with impanel a jury, or option B, find him a predicate.
Your Honor, I think we had three options there, and I think that the reading of that paragraph shows that we were arguing that Erlinger may not apply, but
you didn't support that with anything.
I think
you just said that one statement. Is that enough?
that's not all we said, Your Honor. We quoted Justice Wiley's decision, and we also pointed to the exact argument we're making on appeal, which is that the fact-finding in Erlinger is fundamentally different than the fact-finding at issue here. I believe it's the exact same string cite that we listed in that letter that we cite on appeal. It's the same arguments, Your Honor, and this court should find that it is preserved. And if it does find that the issue—
Aside from this letter, where in the record below do you argue that Erlinger does not apply?
Your Honor, it's not in the sentencing transcript, but this letter was, I think, filed the day before sentencing. And I think it's clear from the time that the resentencing occurs that the judge has already made up his mind that Erlinger applies.
Whether that's true or not, you still have a duty to preserve it, right?
Well, Your Honor, I think the letter does preserve—
The letter does that.
Yes, and I also think that Justice Merchan did consider this because we know that he cited to Justice Wiley's decision in deciding that Erlinger applies, and I think that shows that he did consider this argument, and I think there's an adequate factual basis for this court to consider it. The people filed a predicate felony statement alleging that the defendant was a mandatory persistent. At the same time as that letter, the people filed incarceration records. There would have been no reason for the people to file those records if the people only wanted a jury impaneled, because we would have just entered it at trial. They had already been turned over to the defense. The only reason for the filing of those incarceration records at that point—
We find just by the very nature of requesting for a jury to be impaneled, you're basically conceding that you're not willing to pursue that argument to its conclusion and get a formal decision from the court. Like other courts clearly have made formal decisions, Erlanger does or does not apply, but this court never really got that same opportunity to make the determination as were made by the other judges, because the people asked for the impanelment of a jury. So, especially because this is the first time we would really be considering it, why shouldn't we wait for a case where there really is a fully developed record and a fully developed decision from the court below as to why it is or is not deciding that Erlanger applies to this particular situation?
Your Honor, I don't think the people were only asking for a jury. I think they were making alternative arguments, which we are permitted to do. And another reason this court—
finding from the judge that, and a reasoned ruling from the judge, I am finding, despite the arguments of the people, that Erlanger does or does not apply to this case.
I don't think it's said in those explicit words, Your Honor, but I think he moves right past that and says, okay, the jury, if a jury can't be impaneled.
Isn't he finding about you're not getting a jury because it's not authorized by the statute, and I am applying Erlanger because I'm only going to sentence him as a second violent felony offender. Isn't that what happened?
Yes, and I think he's clearly applying Erlanger, because if he was not. He would have sentenced him as a mandatory persistent. I also just want to clarify something. The people cannot waive the defendant's predicate status. This court has said that over and over again. The people, even if the people fail to file a
Can't be
PFS.
negotiated away either, correct?
Correct, Your Honor. So the fact that maybe this is a concession by the people, we can't concede this issue. And this is a substantively illegal sentence. And just turning quickly to the merits before I address them more fully on rebuttal, there's at least 3 reasons that this court should find that Erlinger is inapplicable. First, directly applicable Court of Appeals precedent has rejected this exact claim by the defendant in Bell and Porto. Second, the factual inquiry at issue.
Before or after Erlinger?
It's before Erlinger, but it's post Apprendi. And Erlinger does not provide that compelling justification to overrule Court of Appeals precedent. Then just quickly, the third point is just that the factual finding at issue here is in mitigation of punishment rather than in aggravation of punishment. I'll address the additional points on rebuttal. Thank you.
Thank you.
Go ahead.
Thank you. May it please the court, Samuel Steinbach Pratt from the Office of the Appellate Defender on behalf of Mr. Moore.
Counsel, how do you respond to your adversary's position that you can't negotiate away, you can't ignore the predicate felony status? That's something that has to be dealt with.
So it is mandatory, Your Honor, but arguments about this do still have to be preserved. I apologize. As the Court of Appeals mentioned.
So why shouldn't we read that letter as the people arguing the alternative? We don't think that Erlinger applies, but if you do think that it applies, impanel a jury, and if you don't want to do that, at least find him a predicate.
So the reason you shouldn't read it that way is just because that's not what it says. As I think your questions were getting at, what they ask for very clearly is impanel a jury. If you're not willing to do that, sentence him as a second violent. They do say, by the way, there's this recent decision where a court found that Erlinger didn't apply, but they make abundantly clear they're not adopting that position, and they don't ask the court to adopt that position, to adopt that argument, or to ever make the findings. And then at the resentencing, the court...
But the letter clearly said that the people don't think Erlinger applies.
I don't think it does, Your Honor. I think they hedge on whether
Justice
they think...
Rodriguez read the language. I mean, it's plain English. We don't think it applies.
The language, Your Honor, is there's an argument that Erlinger doesn't apply. I think they sort of hedge, but they
But why isn't that they're covering all their bases, right?
So because they specifically say, after citing this language, what we want is a jury. And then at the resentencing, the court says, and this is at pages 311 and 312 of the appendix, I'm going to summarize your position, and if I misspeak, please correct me. You're asking this court to swear in the jury. In the alternative, you're asking that the court find that he is a predicate violent felony offender. And the people don't say, no, Your Honor, there's a third option, which is to find that Erlinger doesn't apply and just make the findings yourself. The people say, yes.
What about your adversary's argument that by them submitting what they needed to submit for the 40-year conviction, right, to make him a persistent, mandatory persistent? I'm not sure. To make him a mandatory persistent and the court not accepting that by its essence, the court is rejecting that Erlinger applies. I mean, I'm sorry, ruling that Erlinger applies.
Yeah, so I think the problem with the idea is that just by filing these papers doesn't by itself make the argument for them that Erlinger doesn't apply.
But it's a sentencing proceeding, right?
Yes, but just by putting in these papers about his prior incarceration,
The jury issue is in effect also ruling on Erlinger, because if you felt Erlinger doesn't apply, why do we need to talk about a jury?
I think that you can rule that the criminal procedure law prohibits impaneling a jury regardless of Erlinger, so I don't think that it...
Right, but if you're not thinking about Erlinger, there's no reason to even consider this, because the jury only comes in if you're applying Erlinger.
Sure, but the reason that we're in this...
So the court, in denying a jury, did in effect say, I'm applying Erlinger, and there's no jury.
So to be clear, I think it is fair to say that the court found that Erlinger applies. The reason that's not sufficient for preservation is because it's not enough that the court rule on the issue.
Isn't the rule that if the court rules on something, that preserves it?
Only in response to protest by a party, and here the problem is there's no protest, right? It has to be in response to an objection by a party, not just a ruling in the void, and this gets applied all the time when you've got co-defendants. We cite the cases in our brief, the Lombardo case from the Court of Appeals, where they held that an objection by the prosecutor didn't preserve an issue for the defense. This is a common rule of preservation that applies to all litigants equally, and if they want it to be reviewed on appeal, they need to present it that way. And the problem is, not only did they not preserve it, it's much closer, I think, to a waiver because they affirmatively mention, hey, there's this other argument we could be making, but we're not going to make it, and we don't want you to do that. That is a knowing relinquishment of an argument they could have made. And so having made that decision below, I think they're stuck with that litigation choice.
So where does that then leave us? Are we then prohibited from pursuing or discussing or determining whether or not Erlinger applies? And if we do reach that issue, why would it apply?
Sure. So to take those in turn, I think given the lack of preservation, there's no reason for the court to decide what is clearly a consequential issue that is going to come up. It is already percolating rapidly through the lower courts. This court is going to get a chance to rule on Erlinger with a full record and a full decision from the court below. I don't think it should rush to decide it on this half-baked record. As to why Erlinger...
So I'm sorry, so you agree that this record is sort of incomplete for us to make the determination as to where Erlinger applies?
I think that this record is incomplete for you to opine on the merits of Erlinger either way because the people's failure to take a position deprived the court below of an opportunity to issue, a full decision that it might have had after complete
I'm sorry to
adversarial
interrupt
briefing.
you from my colleagues.
Not at all. And just briefly, why Erlinger, if you were to reach the merits, why would Erlinger apply to a case like this? Is because the rule as clarified by Erlinger is that any fact that increases the sentencing range, unless it's the fact of a prior conviction, must be found by a jury beyond a reasonable doubt unless it's admitted by the defendant. The prosecution conceded below that tolling was just such a fact and that it aggravated the sentence, contrary to what they're saying now.
You're saying the prosecution conceded that tolling is a fact-intensive inquiry?
No, but the question isn't whether it's a fact-intensive inquiry, Your Honor. The question is just whether it is a fact that increases the sentencing range. It doesn't matter whether it's simple, doesn't matter whether it's complicated.
No, because in Erlinger, the analysis went based upon whether or not it was a fact-laden inquiry. And the reason why Erlinger went, maybe, we don't know, is under the analysis of the ACAA and how it applied to the statute that was increasing the sentence. And that required to find out whether or not there were these 3 different offenses.
Yeah, so I respectfully disagree that it's about whether it's fact-laden. In fact, Erlinger has a pretty extensive section rejecting the idea that straightforward inquiries are exempt from the Sixth Amendment, and they say over and over again, any fact other than the fact of a prior conviction. Yeah, I would just note that in, again, the People's Position letter below, and this is at 144 of the appendix, they mention, because the question of whether the defendant must receive an enhanced sentence requires a calculation of the time he has spent incarcerated over the last several decades, its resolution requires factual findings beyond...
Let me just interrupt you for a second. Let's assume that the only issue is tolling. Would that require a jury under Erlinger?
Yes, Your Honor, because...
Why?
Because tolling requires findings, as the people said below, about where the defendant was incarcerated and for what period of time.
Does it matter where? It's just that he was incarcerated.
No, but I think you'd have a hard time proving someone was incarcerated without incidentally proving where. But yes, you have to prove that he was incarcerated for some period of time. That is a factual finding that is beyond the pure fact of a prior conviction, and it aggravates the sentence.
Just to take you back about the preservation issue, the fact, if Supreme Court ruled on it, whether they issued a full decision on the subject or not, that doesn't affect its preservation.
So it doesn't preserve it because it didn't come in response to a protest by a party.
I understand that, but you said something about there's not a full decision. I mean, we don't need a full written decision from Supreme Court.
Oh, no.
In order to...
No, it's unpreserved either way. My point was just that this is a poor...
You otherwise think it's unpreserved, but it's not because that there isn't a decision from Supreme Court.
Correct. I was just making that comment as to why this would be a poor vehicle to reach out and decide the issue.
Thank you.
Thank you.
Your Honors, I just want to turn quickly to what I think even counsel believes is our preserved argument, which is that if Erlinger applies, the court should call a jury to determine these issues. And this court can reach that issue without reaching whether or not Erlinger applies and can just assume it. And the trial court would be permitted under Judiciary Law 2B3 to impanel a jury for that purpose. The Court of Appeals has approved of trial courts.
The predicate felony statute here contemplates a hearing after conviction, right, to determine the predicate felony status.
That is true, Your Honor.
That's in conflict with your request for a jury.
Your Honor, I think, but at the time we get to whether or not we should impanel a jury, it's because, as opposing counsel has argued, that CPL provision is invalid and it should be
Does
severed.
every predicate felony sentence require a hearing? Doesn't every predicate felony sentence require a hearing?
Only if the
If
defendant
there's
is
an
able to make.
objection to something, but the statute refers to as a hearing.
Right. And I see that my time is up, but we do believe this issue is preserved, and there has been just upheaval in the trial courts on this, and this court should issue a ruling one way or the other. And if there are no further questions, we ask that you reverse. Thank you.
Thank you. De Winter versus Equinox Greenwich Avenue.
Good afternoon, Your Honors. May it please the court, my name is Gennaro Savastano from Elefthrakis in Panic. On behalf of plaintiff appellant Ariane De Winter, we respectfully ask this court to reverse the subject order because Supreme Court got it wrong here. There are numerous questions of fact with respect to whether defendant Equinox breached its duty of care to its patron, Ariane De Winter. The first of which I would like to address is the fact that they failed to provide a safety gantry harness. The manual specifically recommends it, especially for elderly patrons. Defendants ignored this argument below. All three of their witnesses didn't even know what a safety gantry harness was. That's Cortez, the assistant manager, Lopez, the complex maintenance manager, and Kershaw, the general manager. So obviously there's no dispute that their treadmills were not so equipped. On that basis alone, the motion should have been denied. Equinox also ignored and or violated a number of mandated warnings from the manual, and a lot of those mirror the ASTM standards. Among those warnings were that you keep instructions accessible at all times in the immediate vicinity of the treadmill. There's no dispute on the record. There were no warnings anywhere. There's also a requirement that warnings be permanently affixed to all
Some of these claims sound more like product liability claims rather than negligence claims against Equinox. Was there any product liability claim brought against the manufacturer of the treadmill?
No, we never alleged a manufacturing defect claim.
Because a lot of these sound like, the things you're arguing sound like manufacturing defect type allegations as to how they're designed or.
Your Honor, as you know well, to an extent, negligence under New York's common law does mirror some elements of strict product liability. We never alleged a manufacturing defect. They do have a duty to warn and protect under common law negligence, which is our claim. Now, their papers below were structured, and I give them credit. It was smart, it was clever, and Supreme Court fell for it in terms of manufacturing defects, saying there was no defects. We didn't have notice. Look how perfectly it works. Well, our argument was that this is not a manufacturing defect. It was this machine not only worked well, it was a Frankenstein machine that worked too well.
But there's a broad, as you know, some assumption of the risks, that when you get on a treadmill, you assume the risks of the treadmill. So what are you specifically, and there's no dispute that the treadmill was functioning properly. So if that being the case, then what is the viable claim that gets to go forward, and why isn't it swallowed up by assumption of the risk?
Your Honor, this could not be further from an ordinary treadmill. It is a souped up, they called it revolutionary. They called it radical. They called it rule breaking. They
Didn't
said,
it work? I mean, is there any allegation that it wasn't working properly, that
Your Honor,
something was broken about it?
there are heightened risks. This treadmill, this is really designed for high intensity interval training, okay? That's why it has these functionalities pertaining to speed and incline, and all of these potential programs in it, which is what my client was a victim of. None of them have anything to do with an ordinary treadmill. She always went on a treadmill. She did 3 miles an hour. She did 0 incline. This can go up to 25 incline. There's testimony about how it can go from 0 to 12 point. A normal treadmill of this kind can go to maximum of 12.5, but that there's added, upgraded capabilities, which this treadmill goes to 15. So we know they have souped up capabilities.
Why does that make them, so it's a very effective treadmill, why does that make them liable?
Oh,
that she got
because
hurt on?
because you have to. First of all, besides the warning that it's conceded, that it's uncontested, that they never placed, which should be on every treadmill, this treadmill had unreasonably heightened risks, and they never argued assumption of risk. Okay, it was not preserved. You can't. No amount of familiarity with regular treadmills would have prepared Ariane DeWinter for this treadmill. I connect those dots very clearly in my brief. I hope the court takes seriously all of the representations that they made about how unique this was, because that's the heart of our case. And it's what the Supreme Court didn't decline to grapple with below. They fell for the manner in which the defendant framed it, which is not even our claim. Our claim is the heightened risks. I think I connected all of those dots, and I see that my time is up.
Thank you.
May it please the court. John Garcia on behalf of the respondent, Equinox Greenwich Avenue. This court should affirm Justice Strauss.
What's wrong with that argument, that this is not your typical treadmill? This is a very different treadmill, and because it was so different than a regular treadmill, there was even a heightened duty to warn about the particular dangers inherent in using this treadmill.
What's wrong about that argument, Your Honor, is that there's no evidence in the record that plaintiff was using any of the heightened features of the treadmill. She, in fact, did not select any of the programs or other advanced features of the treadmill. So therefore, it's completely irrelevant. And to her, it was just a regular treadmill. And to that end, the treadmill was perfectly functioning as plaintiff effectively concedes.
No defect.
Correct. There was no defect. There's also a complete absence of notice of any defect here, as Justice Strauss correctly found below, because the Equinox complex maintenance manager inspected the subject treadmill the day before, and he documented that inspection in an email, which is
Also inspected immediately after.
and it was also inspected immediately after the incident found to be working. And tellingly, the machine remained in use for years.
Any accidents prior to this?
There were no accidents prior to this. It had been installed brand new about 1 month before, and there were no prior accidents or complaints. The machine remained in use after for years without any incident. Simply put, there's no evidence of any defect. There's no evidence of any notice. Everything, or almost everything raised by plaintiff is simply a claim that should have been a product liability claim against the manufacturer that they did not bring. No questions. Seeing no questions from the bench, we rest on our papers and request that the court affirm the decision below.
My very able adversary just proved my point. We're not making those claims. He's arguing against a straw man. So I'm asking this court to meaningfully grapple with the actual arguments we're making. We said in our opposition papers below, look at defendant's memorandum of law. They use no iteration of the words assumption, risk. It's never in there. They never argued it, and so it's not even preserved. But to say that there's no evidence in the record that my client didn't use one of those programs, she was catapulted to such an extent. This is a 79-year-old woman. She's now 84. She was catapulted to such an extent that she needed a partial knee replacement and a shoulder surgery. This doesn't happen. I mean, this doesn't happen from a woman who walks 15 minutes at 3 miles an hour with no incline. She knows how to use a treadmill. This is not a regular treadmill. So I think the court understands my arguments and the record. And unless you have any questions, I'll rest on my papers.
Thank you very much.
Thank you.
And our last case on the calendar today is Etage Real Estate versus Stern.
Good afternoon, Your Honors. This is, may it please the court, Joshua Liston on behalf of the appellants in this court who are the defendants below. Your Honors, this appeal turns on law of the case and the high barrier set by New York.
Can I just say?
Sure.
I'm very confused by this case because of the procedural posture by which it's coming. It's not a motion to dismiss. It's coming up in the context of a motion to amend, but is being argued as a motion to dismiss. But even if these three, the amended claims are not viable, they're the same claims as the original claims. So even if we find there's no merit to the amended claims, the original claims still exist, but your arguments go to the original claims too. So I'm not sure why this is being decided, or why you're appealing the motion to amend rather than just making a motion to dismiss the amended complaint, where we could do this in a holistic manner and decide your motion to dismiss. I know it's a long question, but I'm just mystified.
That is a very fair question, and it also goes back to something that which my predecessor counsel had done, is that when my good adversary had moved... Sorry?
It's a mess. It's a mess.
Yes. When there was originally a motion for summary judgment the first time around, I think we probably should have cross-moved then, because I think what the First Department's decision prior showed is that there's just infirmities that can't be cured and aren't cured by the amendment.
What happens then if we decide this motion to amend and decide there's no merit to the motion to amend? What then happens to the original complaint, which is the same claims? It's not like they added different claims onto the motion to amend. They just added different factual allegations. So I don't...
What I anticipate happening if there's a reversal and saying that the motion to amend should have been denied is that you're correct, that prior to this...
What's left? So what's left?
What's left is the remains of the first two...
If we don't allow the amendment, what's left?
If you don't allow the amendment?
Yeah, what's left?
The initial complaints, two claims, are technically alive, but we would submit on life support, and we would make a prompt motion.
Hanging out there?
And we would make a prompt motion for summary judgment ourselves. And we think that motion would be compelled under the prior rule.
What claims survive absent an amendment?
Would the claim survive? I mean,
what claims survive absent an amendment?
I mean, the two claims are there. They were not dismissed the first time.
Same claims. It's not.
There's a third claim that's added.
Additional allegations, right?
There's a third claim that's added, but I don't think it meaningfully moves the ball. Right. But you're essentially dealing with the same core of facts. So
even if we denied the motion to amend, you'd still have to do something with respect to the original claims.
Yes, but we think what that is a motion for summary judgment, and we think that it would be the lower court would be compelled to grant it based on the prior opinion in this case.
It's just a weird way to even talk about these claims.
I completely understand. I guess the one thing I will add too is that if the court were to move in that direction, I would also ask that the subpoenas be quashed so that at least that issue is starting fresh.
That's a problem because the claims, even if we indicated we don't think the amendment has merit, which obviously we haven't decided yet, but even if we held that, the original claims still exist because they haven't been dismissed. So that impacts how we would rule on the subpoenas because the claims are still going forward.
Understood,
even if we
although
find that the amendment has no merit.
I completely understand, and I'm not trying to suggest that there isn't a mess. I'm just trying to suggest a way through it. And I think the way through it is to reverse, to quash the subpoenas, and then I have to do my job before the court below to try and get the remaining claims dismissed. As I said, if predecessor counsel had cross-moved for summary judgment, I don't think we would have been here.
Justice Kern is asking you, if something survives, what's the justification for quashing the subpoenas in their entirety?
Two reasons. One, there already was discovery in this case. This was not the original summary judgment motion that my...
But they say there's more discovery that they want.
Well, let's have that argument, but part of and this is my second point, part of the reason why these subpoenas were granted, it was part of the same motion. So the court below assumed the case, I don't want to say was starting from scratch again, but would be operating under a different complaint. And so this isn't to say that they would be precluded from making an argument below that because the first two claims are, as I say, on life support, that they shouldn't be allowed to do something about it, but it should be reset and a decision made on the subpoenas independent of the motion to amend, which again we think is precluded by the prior First Department decision.
Yes, you can't really answer that, but I don't really understand the strategy of appealing the motion to amend rather than just making a comprehensive motion.
I understand.
You don't get rid of the causes of action, they still exist.
I guess the problem that we face is that those original claims still exist, independent of anything we do with respect to the motion to amend. It had
Right,
passed.
but you let the amendment go forward and then you move to dismiss the amended complaint, or for summary judgment on the amended complaint.
Fair, fair. We certainly were applying the standard on this appeal that you should look at the motion to amend with the standard of a motion to dismiss, but I take your point that substantively we may not have gone all the way there.
Okay, thank you.
Thank you.
Afternoon, Bruce H. Letterman for the plaintiffs and respondents on this appeal. Absolutely nothing in this court's prior decision, which I believe Judge Kearns, you were on the panel of, and Judge Pitt Burke, you were on the panel of, in any way suggests this case is on life support. All the prior decisions said, and I argued it, counsel wasn't here, was that Judge Engoron did not make sufficient findings and that specific facts standing alone might not be sufficient.
It was coming up in the procedural posture of the court having granted summary judgment to you on piercing the corporate veil. So we clearly were looking at it through that particular lens. So you're right, nothing in that decision, although we do indicate some thoughts about the merits, which are not good for the merits. We don't make any dispositive rulings since we're reversing the denial of summary judgment to the plaintiff.
Correct. And what I would submit is the original complaint, it was just added to, but has basically the same causes of action, that there was an abuse of the corporate form, and just to clear it up after this decision, we amended the complaint.
Right, but
the
by
same
denying
actions.
by saying it was inappropriate to grant you summary judgment, we also didn't rule out subsequently granting a motion to ultimately dismiss those claims.
No, you didn't deny that. You didn't make that decision. You also didn't make a decision whether or not there was additional discovery. As we laid out in the papers, we went through discovery, and the plaintiffs, excuse me, the defendants, the principals, who were among the most successful developers in the city of New York, sat there and said, I don't know, I don't know. We asked for tax returns. They gave the first page. They said, that's the complete return. That's why we had to subpoena the accountants. They had financial statements initially saying they were worth $260 million.
Counsel, why don't you address on the merits, I mean, to pierce the corporate veil, you have to show a wrong. So what was the wrong here that would be sufficient to justify piercing the corporate veil? Other than breach of contract, which is obviously not sufficient. All you're claiming is that vis-a-vis you, they breached their contract by failing to pay the consulting fees, but that's really not enough. So what are the wrong?
It's much more than that, if I can. It starts off that the transaction goes ahead because they represent, they have a company which has indirect interest in the company worth $260 million. They then immediately transfer the indirect interest with the same people signing the documents to another company. Now that, the court said that might be standing alone a breach of contract. But in the context of this, then they cannot explain what happened to the $260 million that they provided financial statements that said, given under penalties of perjury in the penal law.
How does that go to a wrong directed towards the plaintiff, that the domination was used in such a way to commit a wrong vis-a-vis the plaintiff, which is a cardinal requirement of a piercing corporate veil?
Among other things, you sign over and transfer all your interest in an asset that you had just purchased and valued for $18 million. You sign it away using your hat on one company and say, well, that was from this company, that was this company. That's exactly what I submit. A jury could look at it and say, wait a second, that's terrible. That is an abuse.
That wasn't even the party you entered into the contract with.
The contract provides that the defendants have an indirect interest that they shall maintain. They then transfer that interest out, and then as the court sees from the history of the case, I see I'm running out of time, they engaged in a series of moves to delay actions. There were 11 extensions. There was actually a statement, we'll pay it. There was a tape recording of the conversation. And then after 11 extensions, they say, wait a second, this corporation has no money. Then they go to a point where we bring the first action against the corporation. They default. We go through a series of events where Michael Stern, the same person, moves to dismiss the default, moves to vacate the default. Judge Branston says it's the thinnest of vacator, but the appellate division, she was at the time in the Supreme Court, says let it be decided on the merits. Then as soon as that happens, their counsel withdraws. They end up delaying entry of judgment against the corporation with the same people. Michael Stern saying, signing for everybody, delay entry of judgment, and then years later they say, oops, we've distributed all the assets of the corporation, although when I asked them, they couldn't explain what happened to the $260 million, except they say, oh, you have a company, it's gone. That is, I submit, evidence that a jury could listen to this whole story and say, that is clear abuse of the corporate format. They start off saying, we have a company worth $260 million. They use the court system to delay things. Years later, they've delayed things and there's no entity that has any money. That's why I submit there is evidence that under the standards this court quoted, which are that there's an equitable reason, it's a loose statement of the law, but it is the law, is quoted, the elements of piercing the corporate veil are that the owners exercise complete dominion, and such dominion was used to commit a fraud or wrong against plaintiff, resulting in an injury to plaintiff.
Thank you.
That's the pattern jury instruction. Thank you, Judge. Judges.
Just very briefly, all of what my good colleague said was before the court the first time around. And I don't begrudge plaintiffs for seeking leave to amend. The issue is that you still run face first into the prior decision, which pointed out that there weren't sufficient facts of dominion. And I would submit there's no improvement there in terms of the amended pleading. I mean, all of the ones that are in the amended complaint are at page 20 of respondent's brief. And it essentially is that Mr. Stern owned this company and acted on behalf of the company. That's the full extent of it. I mean, on page of 211, 82nd, 633, this court identified allegations that weren't made, and those like ignoring corporate formalities, like doing this for a personal benefit, like abusing the privilege of doing business in the corporate forms. Those still aren't there. And nothing has changed the fundamental issue that the judgment debtor didn't transfer a single thing. It was a different entity.
Thank you.
Thank you very much. I've never had this.
I had this.
I'm very close, but not
Yeah.
actually last.
All right.
I know that was you. So look, you give it away. You give it away. You don't have a good poker face. You do? Have a good night. What?